Court is now in session. Honorable Camara Banfield presiding.
Thank you. Please be seated. Good morning. Your department has family law docket. Please, if you're on mute, keep your devices muted. Your camera's off so your case is called. Once your case is called, please unmute your device and turn on your camera. I'll go in order of strikes, readinesses, and then the order of the docket. If you don't hear your case called, please let me know by the end of the docket. Okay, great, thank you. I'm gonna put my docket on. Oh, here, got it. Okay, perfect, thank you. Okay, number 2 on the docket is the low matter, class number 1530305555. It is set over to January 19th, that's 2 and 3. Number 15 on the docket is a strike that was heard on 11/13. I think those are the only strikes. Number 5 on the docket is the leaf matter. It's on for readiness and a hearing for contempt. That's cause number 1830231351. Looking for Tiffany and Harris.
Present.
Come on up. Good morning. You guys can both stand up here at the bar. Okay, so we currently have trial scheduled for the 9th of January. Are the parties prepared to go to trial?
Yes.
I've submitted a temporary or a suggested parenting plan in concession with the guardian ad litem report. I'm not sure if she's refusing or not accepting that.
I didn't think we were doing that until we went to trial, Your Honor.
Yeah. So we have a trial date set. So are you guys are you trying to negotiate with Tiffany?
That was my intention.
Mm-hmm. Tiffany, are you wanting to negotiate?
I want to adopt the parenting plan submitted by Thomas Hahn, the guardian ad litem.
Mm-hmm.
I believe he is on via Zoom.
Mr. Hahn, are you here? I saw you earlier. Would you like to wait till he comes back on?
Yes, please.
Okay, have a seat. Number 1 on the docket is the Sheldon and Fortis case, number 1530131197, came from Michael and Carrie. Good morning.
Morning,
There's Mr. Hahn again, upside down. I'll recall that case, Mr. Hahn, unless you're on this case as well, I don't know. Good morning.
Morning.
So we were waiting for the evaluation of the report, and one's been issued at this time. I know, Ms. Fortis, you wrote a significant response to that report. So how would you like to proceed at this point?
Well, I also put in a temporary parenting plan that just has me have the weekends. So I would like to do that.
Mhm.
My, sorry, I'm really nervous.
Yeah, no worries.
My personal evaluation is in there, and I check out just fine according to the Dr. Lee. But I do want to have Dr. Lee's reviewed because it's incredibly biased.
Mm-hmm.
And the first, I have a guy that can do it up north in Bellevue, but he's not available until May.
Uh-huh.
And so I would.
What's happening currently? I'm sorry, you guys, with visitation.
So every other weekend I have an 8-hour visit, both Saturday and Sunday. I think it was 8 hours, is it 8 hours?
Yep, it's from 10 to 6, drop off to pick up.
Okay.
Saturdays and Sundays every other week.
And we don't have a current trial date set on this case?
We don't have a trial date set on this
And
case.
you guys want to go to trial on the case, obviously, since you're not agreeing on the issues.
I don't know if we're ready for
I
trial.
would like to make an agreement with him.
Well,
I think the kids should stay with you. They've
well,
been
we're
there
not
for
gonna
so
talk to
long.
each other, we're gonna talk to the judge. So, sir, what were you saying?
I don't know if we can financially afford attorneys to even go to trial.
You could go to trial without attorneys, you just
Okay.
present the evidence yourself. I mean, I'm not gonna make a decision without having a hearing that's significant besides what we're hearing from everyone else to it.
The main issue is the addiction, that is still a problem, the alienation, and the weaponizing domestic violence against me to the kids that's causing emotional harm, as stated by Dr. Lee. That's a main problem. The temporary family law plan, parenting plan from 2019 states that she needs to comply with all recommendations for treatment. Dr. Lee recommends a big plan inside that evaluation. We can set for trial if you'd like, but I think getting into treatment would be beneficial for the
Well,
kids.
okay, so if you, then we, I guess we don't have to go to trial on this, but right now we're sitting here and I'm not gonna I'm not gonna have Carrie, we're not gonna be able to make a plan right here with all of
Right.
this. So we could schedule a special set hearing, like in a couple hours, so we could sit down and figure out what that looks like. Carrie, are you intending on following any of the recommendations of Dr. Lee?
Well, which ones? They were quite extensive.
Okay.
Not drinking, yes, I absolutely do. I will follow, and I submitted a hair test to show that I have not been drinking.
What do you think about that hair test? It was very clear that, I mean, that's a significant test.
Right, but it does go, it's past 90 days from when the question was in place. The ETG urine sample that was put in place for the verbiage was not taken. I have proof here that I asked for it. Dr. Lee and I never received it. ETG really specifically from what I've read is for binge drinking, so taking a 90-day sample past 90 days from when the question was going on. She even admits that she was drinking through an attorney. She knows that drinking's an issue. I think it's sort of like, hey, look, I'm clean and sober 90 days later. This is her pattern. She gets sober.
Jen, I need a 2-hour special set.
Okay,
Why don't you guys have a seat and I'll get some dates for you.
perfect.
Number 4 on the docket is NRA, the parenting of and support of Perry, cause number 16-30159 1.
Good morning, Your
morning.
Honor. I represent Ms. Anderson in this matter.
Good morning, Your Honor. Jim Sansone for Mr. Perry, the respondent.
Thank you. You probably don't know this, but I'm really hard of hearing, so you're gonna have to speak up.
Yes, Your Honor.
Thank you. This is regarding relocation. The relocation is simply to Wilsonville. Dad's objection to relocation. And it appears that the relocation will not affect any of his parenting time except for time in the vehicle. Is that
is
accurate?
correct.
Okay.
Absolutely.
Okay, so, my understanding as well is that, I might be confused with another case, but that, Ms. Anderson has no intention of moving until after the end of the school year?
That's correct.
Okay. All right, so, what would you like to do? I'm sorry, I didn't catch your name, sir, again.
Jim Sansone, Your Honor.
Spell it for me,
SANSONE.
thank you. Mr. Sampson, what would you like to do at this point?
Well, Your Honor, my client still doesn't agree to that, but with my understanding, this is also on for my client's motion to appoint a guardian ad litem. So, it doesn't sound like the issues are too complex. I don't know the court's inclination. I do know under RCW 26.12.175, it is in the court's discretion to appoint a guardian if court deems it's in the best interest of the child based on the past allegations of inappropriate behavior, which led to 2 unfounded CPS reports in Florida, and based on my client's concern that the child's being coached, we would like a guardian appointed to investigate and then have basically any of those findings incorporated into the trial on the potential move away and or modification of custody and visitation.
Can Can I respond here?
Yes.
So I think what Mr. Sansone is bringing up is that his client, in different terms, is unhappy with the outcome in 2021. So he's trying a second bite at the apple.
Yeah.
So he's trying to retry what happened then with
Right.
Judge Collier. And it was very specific, the findings that Judge made. And he was to go through two different phases and then get to the one that he's in now. And that's been going okay. I mean, they don't get along great, and that's one of the reasons why there wasn't a 50-50 amongst other things back then. So our position is that that would be a waste of a guardian ad litem's time.
Oh, it'll be a waste of somebody's money. Yes, sir.
I'm Matthew Perry.
Would you like to come forward, sir?
I just want to note that CPS was just at my house investigating again on a new allegation.
Okay.
And we know nothing about that.
Okay.
It may have nothing to do with my client. I don't know.
Okay.
Well, that's the whole point of the guardian, Your Honor, obviously.
Okay. Well, I'm willing to appoint a guardian ad litem because we're gonna obviously go to trial on this, but it's not, your client hasn't filed a motion to modify, obviously, this opens up the modification process in some form. I'm willing, it'll be at your cost, and then we'll reserve, to later, change those costs. Is that what you wanna do, Mr. Perry?
Yes, ma'am.
Okay. Do you have any objection to that?
I do, Your Honor, I just don't think it's necessary. The move is such a short distance.
Yeah.
And if this was gonna be a deep and dark custody battle,
Right.
that would make sense to me,
Yeah.
but the presumption is in my client's favor.
Yeah, the presumption is in your client's favor. I'm not going to listen to anything that has to do with the modification, there was been no modification filed. But if you want to, bring on a guardian ad litem at this point to tell us that it's not in the best interest of the child to move 30 minutes down the road, then I guess we can do that.
Yes, Your Honor, we want the guardian appointed for amongst other reasons.
Okay, well, the other reasons is the part I'm trying to limit you to. You haven't filed a motion to modify. You just had a trial on this issue, not just a couple of years ago. Nothing's changed since that time. So for me, for this court, the only issue that's before this court is a motion to relocate. And an objection to a motion to relocate when the person has the presumption and the move is literally the same distance as the father had once lived from Longview to where the child lives currently. So it's really.
No, I understand.
Perfect, well, good, all right, so, I think I'll have you draw up that order, so you could be very specific with what the guardian ad litem is supposed to be doing in this case.
And that would be to,
If it's in the best interest of the child to move 30 minutes.
okay. And Mr. Perry pays for this?
Yep.
And do we have somebody that we want to use? Everybody's in very short supply, as you
Yeah,
know.
Mr. Sampson?
I don't have anyone proposed now, but I can get the council off.
That sounds great.
the Zoom.
You guys figure that out.
Okay, sounds good. Do we
Yes.
wanna do entry of orders?
I don't think we'll need to, but I guess we can put something on the books. We could put January
19th is full, your next one's the 26th.
January 26th for entry. Yeah, I'm awesome. Not really.
You are.
Okay,
All right, thank you, Your Honor.
anything else?
I don't think so.
No, thank you, Your Honor.
Thank you. All right, the next one on would be number 7, McMillan. I always say you guys wrong, name wrong, McElwain. Cause number 1830086163. I didn't see Mom.
I haven't seen her either.
Let's take a step back until she gets here.
Okay.
Who's this?
I think
It's
that's
Marina.
the.
Yeah, that's the GAL, sorry, we'll come back to this,
Okay.
guys, sorry. Sorry. All right, number 8 on the docket is the McQuaid matter, cause number 1930132506.
Good morning, Your Honor. Ann Margraf on behalf of Nix McQuaid. Sorry, Tamala, my apologies.
Good morning. Okay. I don't know where my materials went. This is for a motion to enter temporary child support order and a motion for contempt. Are both of those accurate? Or is the motion to enter temporary child support order in front of another judicial officer?
I believe the child support order is in front of you, Your Honor.
Okay, great. So, is Matthew here?
I'm here, I'm
Oh,
present.
thank you, sir. Good morning. So I think there's a motion for contempt as well. So they want to enter a temporary child support order. My understanding is you haven't handed over your financials.
I was asked by the petitioner's attorney to send over documents, and I sent those over to her.
Ms.
Your Honor, we
Margaret?
never received those documents. I believe the DPA received them.
Ms. Ward?
I don't believe we received anything from father. I received mother's pay stubs, which we provided as part of the motion. I don't believe we received anything from father.
I was, is it okay if I speak?
Sure.
I was emailed multiple times by the mother's attorney, and I did submit. I emailed them pay stubs going back from when I started. I do want to also bring this information, new information. I was informed last night by my employer that I'm being let go. So I think that's going to affect numbers moving forward. I don't know.
Okay, wait a second. I'm having a hard time understanding. Matthew, what you're indicating, give me a second. I'm gonna ask you a question. I thought you said you were notified by your lawyer. Is that accurate?
I don't have an attorney.
That's what I thought.
I
Okay,
was
so
The employer, Your Honor.
employer, thank you. I'm deaf. So, all right, so what you're indicating to me, sir, is that you're getting ready to be let go.
As of yesterday at about 4:30 p.m.
Well, that's a bummer. I'm sorry to hear that.
Your Honor, we'd also like to note, we believe Mr. McQuaid is earning money from working on something similar to DoorDash. We haven't received any information on his income from that source.
Okay. Matthew?
Yeah, I do work DoorDash periodically. I make very little off of that, but yeah, I do work.
Ms. Ward, what would you like me to do right now on this case?
Well, at this point, I feel like we've sort of been dragging this on since September, when the court ordered the child custody change. We haven't actually received anything from father.
Yeah.
I'm gonna ask the court to enter the order. If father wants to provide actual documentation to the court, it's a temporary order that can be reassessed based on new information. And I'm asking for a September 1st start date, since that's the month the court ordered the children returned to mother.
We absolutely agree with that, Your Honor.
Mr. McQuaid,
Yes.
do you understand what's being asked of you?
Yeah. I don't know who I'm supposed to contact in all of this. I received a packet from the prosecuting attorney, and I did try to call the phone numbers that were provided, but I haven't been able to get through
Okay.
to them.
Let me talk to you really quick. Sorry. I'm having a hard time trusting and believing you right now, I have to tell you. We've been here before. The last time we were here and you did the thing with the child and took and with withholding and doing all those things, you played ignorant at that time too. So now here we are. We had a process in place. You were supposed to get these documents to them. You've been in front of another judicial officer to do that as well. And here we are, we're still in the same exact position. It's hard to understand that you don't know exactly what documents to get and who to give them to. So, this court is finding you in contempt. I'm going to enter the temporary orders, but I don't have them in front of me for some reason.
No, we just needed the court to make the rulings, and then I can circulate the orders
Sounds great.
based on the court's rulings and have an entry date.
Mr. McQuaid, you can purge this contempt by actually getting the exact documents that they requested. Now, I know you've just been notified that you're gonna be losing your position. I want all the documents from before you lost your position anyway. I want DoorDash or Uber, whatever it is that you do, I want all of it, even if it's for 2 minutes a day. And so I want all of that stuff to go to Ms. Margraf and to Ms. Ward, and then that'll purge your contempt. Otherwise, you'll be paying $100 fine, and you will be paying attorney's fees, because we're here again having to deal with this issue. What did you ask for?
$1,500, Your Honor.
Okay, I'll get $1,000 in attorney's fees. You understand, Mr. McQuaid? This thing gets
I
really
understand.
expensive the more we keep not giving people the items that the court requires. You understand?
I understand.
What-
Who am I giving the documents to? Because
Again, I'll restate it again, to both Miss
Okay.
Ward and Miss Margraf. Do you understand? Both people.
Okay, I don't have contact information for Miss Ward.
Miss Ward is
Can
a member of the state, so you said you've gotten all those things with the phone numbers and the address and everything. Where are you living right now, Mr. McQuaid?
Kirkland, Washington.
Kirkland, Washington, okay. So they only accept personal service, so you have to, it has to go directly to them. You can't email it to them, you understand?
And Your Honor, I just typed in our mailing address in the chat box.
Awesome. All right, I hope this works out. I'd hate for you to have to keep getting fines and stuff. We should just get this information. I know you wanna support your child.
Absolutely, I absolutely do.
I know.
I've been a part
I
of
know,
my-
you seem like a good dad. All right, well, let's have entry be the 26th as well. Hopefully I don't have to see you guys.
Your Honor, if I may, quickly.
Yes, ma'am.
I'd like to clarify, I apologize, we did receive the pay stub, but a full 2 months after the hearing and after multiple requests, and I don't believe, though, that Ms. Ward has received them. And then also, we'd like to address the issue of health insurance. Mixed Mala is covering the children at some expense. We'd like to make sure that Mr. McQuaid's proportional share be entered into the appropriate spot on the worksheets, so that we can have something accurate. And that coverage started in October, not in December.
Okay, great, so
I
Go ahead.
don't mind including that, but I need the actual documentation regarding the costs, which I
Of
have
course.
not received.
We'll send them over, of course, Ms. Ward.
Okay, so it
I
sounds
just
like
received them, I think, yesterday, so.
Matthew, sounds like you did get some of those documents to Miss Margraf, so whatever else, they'll just have to get to Miss Ward now, and hopefully Miss Margraf will send that on as well. But, whatever else that your earnings you're making, please make sure you get those to them, okay?
Yes, Your Honor.
And the only other issue the state had on the child support is whether or not the court will be addressing how the tax exemptions are going to be divided on this order or not.
Well, we'll just have Mom, since we've been dealing with this issue, Mom will, claim this year, and we'll deal with the rest when we get into final orders.
Thank you, Your Honor.
Thank you, Your
Anything
Honor.
else? All right, you guys have a great weekend.
Thank you, happy holidays, everyone.
Happy holidays. Number 9 on the docket is the Doyle matter, cause number 23-014-1506. Good morning.
Morning, Your Honor.
Morning, Your Honor. Grant Brewer here on behalf of Mr. Doyle.
Good morning. Okay, this is on for contempt. Dad filed a contempt because even though they had a 50-50 schedule, their son, who was 14, refuses to go, and he believes Mom is encouraging this behavior and is being the kid's friend and not the kid's parent, and disparaging him for his discipline. He's also moving to modify child support because he was deemed disabled by the employer and only received 70% of his salary. Mom states that disability is due to the drinking problem, that the son found his dad passed out on the couch with a bottle of vodka, and he's very abusive verbally and highly critical of the son, and the son chooses not to be around that. Since the son has not been around his father, he's been excelling, getting great grades, and doing well in the sports. She has a huge financial burden, though, because now the son refuses to go, and so he lives with her full-time. Mom's also indicating that Dad has not included his girlfriend's contributions in the home, so when he indicates that his expenses, they don't include the fact that she pays half of the bills, and that he is very vocal about the fact that she pays half the bills because she deserves to have the same respect he has in the home. So I got that accurately?
Well, except, Your Honor, yes, you do. I guess I should have cut you off because we'll have to set it over because I just got materials from Mr. Whitlock Wednesday on all the financial matters. I just got materials in response to contempt on Monday. They were served a month ago. And my client has a right to respond to all this, obviously. My point in bringing all that up is there's late filings. We're gonna have to set it over if you're gonna want responses to these things, it sounds like. And so we'd ask for a set over and fees for having to show up due to the late filing that Mr. Whitlock did.
Mr. Whitlock.
I contacted Mr. Brower last week and indicated that my client was severely sick with COVID, could not work, was testing negative and had for the whole preceding week. That could we either set it over or get some materials, the key materials to him on Monday. He got back to me on Monday and said his client would not allow that.
I see.
So we got him to him on Monday before the end of the day, so they were one day late.
And they knew.
But and he knew in advance that that was gonna be the case.
Well, I'm willing to set this over without any fees at this point. I guess I could reserve on the issue. How much time do you guys need?
I'd indicate to the court that it's cited in on your docket on January 19th for our motion to change the parenting plan.
I see.
And so it's kind of all the same issues.
Yes.
So I would think it would make sense to set this over till January 19th.
Mr. Brewer?
I agree. It's more efficient to have it on one date. I want to make clear, in the meantime, the parenting plan is still in effect, Your Honor. Is that correct? I mean, there's been no change to it.
The parenting plan is in effect, and this has just been really interesting for me. I'm 2 years now into this family law thing. I have a 14-year-old who refuses to go. What would you like me to do about that?
Well, nothing. I just want to make clear that they have the belief that they don't have to follow it right now.
No, they need to follow it as much as possible, but I'm not expecting her to drag her child over there. But I think it's awful. I mean, it's really sad. We love we pit each other against each other, and I think it's gonna be helpful to our relationships, but it actually hurts the child. So I'll just put that out there, and we can address it on the 19th.
And if you would reserve on fees, because Mr. Whitlock only gave you half the story there. I mean, it's
I will do so.
accurate. He submitted everything on Wednesday afternoon. There's no
I
way
will
we can
reserve
respond.
on fees. I will note that he did indicate that his client was ill. So,
And she
all
has
right.
documents them, so.
Okay, thank you so
Anyway,
much.
thank
I'll
you.
see you guys on the 19th. Have a great weekend.
Thank you.
Happy holidays. All right, so boy, number 10 on this is the Campbell and Diamond case. Cause number 21300933606. Good morning. Looking for Richard.
Can I speak on his behalf?
Whoa, I don't think so.
Can I ask for continuance? He's not able to be here.
Give me a second. Sorry. What's going on? You'll come up here and tell me your name, please.
Larissa Severe.
Spirit. And then, can you please spell your last name for the record?
SBIR.
And then who are you to Richard?
A friend.
Okay, will you raise your right hand?
Yes.
Do you swear affirm to tell the truth in this proceedings today?
Yes.
Thank you. Go ahead.
He's incarcerated.
Oh, poo-poo.
Yeah.
Yeah. All right. What's it for? Do you know?
It's for violating a protection order.
Against Diamond?
No. No.
All right. Well, then I guess we'll have to set the matter over. Do you know when he will be out of incarceration?
I believe Monday.
Okay.
Your Honor, I'd like to bring up a topic here.
Okay, what is it? State your name first for the record.
My name is Devlin Campbell.
Spell your last name.
Campbell.
Raise your right hand. Do you swear affirm to tell the truth in these proceedings today?
Yes.
Thank you. That is some eyeshadow.
So yes, there have been some extenuating circumstances that I just found out on December 10th. I don't know if you recall, in November, you had informed me and Mr. Diamond to get our paperwork together. Informed us
I did
how to
hear about
draft
your
it.
extenuating circumstances. That you think he forged some documents.
Yes, ma'am. And actually, his associate, Crystal, who was in on it, has been texting me this morning. She actually said she'd be here today. I didn't count on that. But I'd like to address that. I never signed that
there's,
quit claim
okay,
deed.
let's stop really quickly. Number one, he's not here because he's incarcerated, so he can't be here. There's nothing I can do about that. We can set that over. The other issue is, there's nothing before this court on your other issue. I just heard about it through the grapevine, but there's nothing that, on the record, I can't really deal
Well-
with it.
Oh, I'm so sorry.
I can't deal with that issue right now, regardless. But what I will indicate when I did hear something like this is that I think the most important thing for you to do is to file a police report, because it's not something
I
I'm gonna
did.
be able to handle. Good, very good. So that's where we are. That's our first steps.
My fear is he's going to sell that house now, because my name isn't on it, or quitclaim deed it to somebody, and then he will never, ever have to pay me for past, present, or future debts.
Yeah.
So what can be done about that?
Well,
I'm
if it's
pretty sure
fraud,
he's
it
gonna
can be
quitclaim it.
undone. If there's actual fraud happening,
Yeah,
that
I'm
will be.
pretty sure he's gonna quitclaim to these guys.
Oh, okay. Well, listen, right now, we can't handle this matter again, I'll repeat that. Number two, I don't have anything before this court on that issue. If you would like to file something, then I will try to do whatever I can do to help prevent any sale or transfer of the home before that time.
What would I file?
Well, you have to file a motion
A motion.
indicating that you believe that there's been
Okay.
fraud in this issue and whatever.
Done that many times.
Okay. All right, anything else?
And one more thing, I believe that he neglected to say that he still had a 401 retirement plan from his previous job. I am signed up through the USPS Daily Journal where they take pictures of your mail and they send you what's coming in the mail every day. And although he did change his address and his mail does not actually come to me, I keep seeing these 401k papers from Cruz Plumbing going to him, which he neglected to mention in the divorce, and if he is getting money, he should be paying me.
Agreed.
And I noticed that in his last, when he came late and you talked to him, he had mentioned he had a job in July, no payment.
All right, Diamond, listen, we're not doing anything on this case today because we don't have him present.
I just like it in court.
I know. But what I will say is, you did the proper job of serving in the proper amount of way. You've indicated that you're representing that for him for this continuance. He knows you're here on his behalf. You will let him know we'll be back here on the 26th at 9 a.m.
Okay.
Okay.
December 26th.
January.
January.
Yeah. Happy holiday.
Don't do that, that's what happens.
Okay, thank you. All right. Do we have, are you guys ready?
We do.
She's here?
Well, we don't.
Okay, we'll go to number, someone want to reach out, that'd be great. Number 11 on the docket is the Smith matter. Oh, that's strike, right? No, we're not yet.
No, Your Honor, not yet, I don't believe.
That's right. So I'm looking for Roger and Kelly, and I got Mr. Davis, but I believe there was another attorney on the other side. Is that accurate?
Not to my knowledge, unless that just occurred this last couple days.
Okay, thank you. Come on up. Good morning. Can you please state your full name and spell your last name for the record?
Roger Corey Smith, S-M-I-T-H.
All right, Mr. Smith. Will you please raise your right hand? You swear from to tell the truth in these proceedings today?
Yes, ma'am.
Thank you so much. This is on a motion to modify child support. This motion is because you have a new child that was
Yes.
born in March of this year. And so you want to modify the child support. Mr. Davis just got on the case, and so he's asking for a continuance. Are you objecting to that continuance?
If they were unable to submit her financials to where they can't.
Okay, let me stop you real quick, Mr. Smith, I'm sorry, I
Sure.
should have done this first.
Sure,
Do you know you don't have a right to modify the child support at this point?
I do not know that.
Yeah, you wrote in your paperwork that the court signed off the child support order on 9/15/2021, which is not accurate. They signed the order on March 25th, 2022, which means you are too soon to modify.
So what do I do at this point now?
Well, Mr. Davis is asking that this matter just be dismissed outright. The reason why I gave you this information was because they're also asking for a set-over, so why don't we just set it over to March?
Okay.
Okay, can I have my last docket in March, please? Perfect. Oh, wait, am I here? Okay, March 29th, I'll see you guys back here on March 29th at 9 a.m.
Yeah, that works.
All right, great. Have a great weekend, holiday, all that jazz.
Same to you.
All right, so number 12 on the docket is a Soggy case. Cause number 22300843006. See Mr. Brewer.
Yes, Your Honor, we've got a number of things in front of you. I didn't get a response from Mr. Pisayan, so I don't know if he's in the courtroom, but I have not received any from him.
Oh, wow, he's here.
Oh, okay.
Yay! I'm really happy to see you. Can you please state your full name and spell your last name for the record?
Yes, my name is Satuan Pisayan, last name Pisaygyne.
Thank you. Can you please raise your right hand? Do you swear affirm to tell the truth these proceedings today?
Yes.
Thank you. I was really glad to see you because I didn't see personal service in this matter, and I was afraid to move forward without it. Since one of the issues is a contempt on something that you weren't even here for, to learn that you'd be in contempt for. So that would have made it unwillingly, not willful. So go ahead, Mr. Brewer, talk to me.
Well, he was properly served with motion on the conveyance of the title, because if you recall, we did the divorce that he didn't appear for, and we entered orders on that. So I have before you a motion to convey title, basically under CR 59 to appoint another party to do that. Also to sign off on the quadros that were also part of the final divorce order. So those three things are properly before you to be determined. Maybe he wants to file a response, I don't know, we'll find out, I suppose. And then on the contempt, we'd ask that to go forward, but if you want to set all this over on one, that's your call, of course. So we want him involved in this, as we did a trial, so we'd rather have that than just default things.
Yeah, thank you. Do you understand what's happening?
Not exactly.
Okay, well, you didn't show up for the divorce. You know that, right?
I didn't know at all.
You didn't have any idea that we were going through this process? No. What did you think was happening?
Well, I know I'm getting a divorce, but I don't know what's the date, when it's gonna be final.
Uh-huh.
So that I don't know. Because all I do, basically, I'm just working day and night.
Yeah, working day and night, doing Michael Jackson.
3 days, 4 days, no sleep, so.
Okay, I'm sorry about that, because it's tough, but you missed the trial. And because you missed the trial, she got everything she asked for, because you didn't show up to say anything. So, some of the things she asked for was the house, your retirement, pretty much everything. And she got it, because you weren't here. So, what would you like to do about that?
That means she get everything as a retirement, or she just
No,
get a
she gets a
half.
portion. Just a portion, but the house she gets as well, you know.
That's fine.
Whoa.
I'm willing to give up on that. Yes.
All right, so Mr. Brewer, do you want an opportunity, can we set this over so you can speak with him? He's probably willing to sign most of your information.
Yeah, that's fine. I've emailed him. I'm wondering if he didn't, he's responded on my emails before, but he didn't respond to any emails I sent.
When did you send the email?
I'll send you the dates again. It's the same email I've used before, but when we filed it, I sent you all these materials by email, and I'll send it again. But
okay.
Judge, to answer your question, what I'd like to do is, he's here now. What's your next available docket? That way I can try and work him in the interim, or he can file something in the interim.
February 2nd, I believe is what I was told.
Sorry, say again?
February 2nd.
Oh, yikes.
Yeah. You want a special set?
Yeah, that would be great.
Okay, I'll go have a seat and I'll see if Jen can get us a special set.
Thank you.
How much time do you need, Mr. Brewer?
I don't think much. We're not
Half
going
hour?
to re-argue the trial.
Half hour?
Half hour is fine.
Okay.
Yeah.
How much time till then? How much time do you need to get it together?
I don't need much. I'll communicate with him, and beyond that, it'll be up
So
to him.
like 2 weeks?
Okay.
Okay, Jen, if you could help out on that, I appreciate it. Okay, number 14 on the docket is the Alexander matter. My favorite. Exactly. How are you guys doing?
Very well.
Good.
Well.
Okay, great. State your full name and spell your last name for the record.
Amanda Lynn Alexander, so you said spell it?
Yeah.
Alexander.
Do you swear affirm to tell the truth in these proceedings today?
Yes.
Thank you, sir. State your full name and spell your last name.
Adam Alexander, Alexander.
Do you swear affirm to tell the truth in these proceedings today?
I do, yeah.
Great. All right, tell me.
I finished my parenting classes.
Wow, does it make you a better parent? Come on, Adam, tell me what's up.
I think things have been going good. So
Part of the normal cycle for you guys?
we're back in the cycle,
yeah,
Your Honor.
mhm.
We're right there.
Yeah, yeah.
As you could
Everything's
probably
good right
imagine.
now, we'll wait for the blow up coming later.
Well, no, it already went past that. We were past that. at
Past
this
it for
point.
good?
Well, I don't know. I feel past it for good,
Mhm.
but I don't know. It's the same circle.
Yeah,
Once we see each other in court,
Yeah. What? It's just like love at first sight again.
all over again.
All over again. And we hate each other. We love
honeymoon,
each other.
divorce, all that.
Oh,
So
God.
we're past the.
What's happening now with the visitation?
Well, I still the same thing that we had. I get them this Friday or today, and then I have to somehow give them back to him on Christmas Day at noon.
That part we haven't figured out.
Yeah, we haven't figured out like a third party or how, but we haven't had to do it yet because the kids have just been doing exchanges at school.
Oh, that's right.
So
That was a smart judge.
Yeah, you crushed it.
but for the holidays, I think it'll be a little tricky. But it's also, I think, going really well.
Are you? Thank you so much. Are you? What's going on with her parents? You're not wanting them to be the intermediary.
The parents is just as conflicted as
Yeah,
ever.
yeah, I
you know?
understand.
It
Okay.
is what it is.
So Amanda, what
I wish
about
that it
this
wasn't.
friend of his with the other child that was kind of the one? I mean, I know that's a
Out of the question.
Okay.
She ain't gonna
Yeah, she's like,
bend on that, on the Mystina thing. And honestly, they've been re-beefing again. Like, once, hypothetically,
Mhm.
anything that moved on with her and I made Mystina mad again, obviously.
Yeah,
So
I
that-
understand that. Don't be letting like that shouldn't have happened.
I-
You were really brutal. Okay, so listen, how old's the oldest?
8.
Oh, that was the
Our
youngest,
oldest
sorry.
is 8.
Our oldest
Our
is 8.
and our youngest is 2.
Well, we gotta figure this out right now.
I think the problem is there's so many orders, other orders,
Yeah.
like the no contacts and stuff, and I mean, I
Want
could
to defer them to
obviously,
you, so.
I could obviously go to like, say, her apartment and drop
Mhm.
the kids off, but there's that other random order from.
Which one is that?
The one that was supposed to be quashed or whatever last time, and I don't think it was, because
Okay.
in the cops database,
And
it's
do you have
appearing.
do you have a cause number for that, Adam?
It's the one through what?
Commissioner
It was
something.
domestic violence to Snyder, or Commissioner Sasser. She did
Sasser.
it, and we were both gonna try to have it all just on whatever you think. If
Mhm.
they'll refer it to family court.
Yeah, we could do that.
That's what I think that it should all go through, Your Honor, because.
Yeah, but you guys will still have the criminal one with Amanda. I mean, with,
Yeah, with Amanda, because that one has already finalized and we have to like put in a motion.
yeah, you've got a lot of stuff to do.
Right, and all of
Have you
that.
started your treatment?
I've been in it the whole time.
Domestic violence treatment, domestic violence treatment.
Oh, no, I haven't paid for it yet. I'm still
Mhm.
not working, so I haven't been able to pay for it. My DOC officer gave me an extension on it until March.
Okay, you know, there's this other thing, this other treatment that I actually think works better, it's called DVMRT. It costs a lot less, it's a shorter period of time, and I think that you actually do more work on yourself in it, so you should ask your DOC officer if they consider doing it. It has to be done through district court's probation, because that's the only one that provides
So
it.
those charges that I was facing is all getting dropped down to misdemeanor, so maybe I could ask for that in my thing. Would that work?
That would work, and so what you could do is ask them to actually refile the case in district court, then district court will have jurisdiction over it, and they can give you the DV.
I wish I would've known that yesterday. I just pled out to something else yesterday.
Oh, shoot, oh well.
Your Honor, I had filed a motion to restrict abusive litigation.
Yeah.
And I,
I was just reviewing that,
Oh, really?
again, last night, so I'm willing to file that, but I'll be putting it mutual. I know that you've been doing a really good job, but I would like to do a mutual,
I don't wanna file no papers on her.
I know, I'm
This
just
is the
saying.
state. I hear you, but I can't really go into them and say, yeah, drop everything if she's gonna immediately
Yeah,
file a PPP.
exactly. No, I agree with you, okay.
Right.
So if you wanna prepare an order for that.
I have the
Okay,
final
good.
order for that.
I don't have time before Christmas to see you guys again, so we have to figure out this drop-off thing. I'd like to get the other order dismissed, but you'd have to cite that on in front of me.
But it won't happen before Christmas.
So what's today?
'Cause we were really trying to spend Christmas together, you know?
Ooh, hey. What? Almost peed my pants. Okay. Oh, that's funny. You're
We
funny.
were she was pregnant again.
None of this is reality. You guys don't know these people, it's really funny. All right, stop it. I will sign this off docket, Adam, and then in the meantime, if you could get me the cause number to the one protection order, then I can at least have you drop the kids off at the house.
Okay.
And I'll do another order that's independent that says you guys are allowed to have contact for transportation purposes of the kids.
Yeah, and like.
And does that override the other one?
It
Because
will.
I'm just not trying to get in any
I know,
trouble.
well, it's gonna be him dropping, so you're not gonna
Right.
get in trouble. He's gonna have to do all the transportation. You gotta not be crazy during this time period. I'm serious. Good luck. All right.
My question for today though is we're only at it every other weekend thing right
Yeah.
now, and I've like
We're gonna stay there for now. Because
Okay.
we'll get this back on. I'll put you guys on February 2nd as well, so we can start addressing other issues. But through the holidays, we're keeping the status quo. I need the clause number for the no contact order.
Do you want me to get it before I leave here?
You can just email it to
Oh,
Jen, and then I will I will dismiss that off docket. I will also do an order, standalone order that says that you guys are allowed, that Adam's allowed to be at your home for the purpose of dropping off the kids.
Heck yeah.
And vice versa, and picking up the kids. Okay? Don't look at each other anymore. All right, I'll see you guys on February 2nd.
You coming back on February?
Yeah, so I can try to deal with the rest of the,
do I have to file this?
that'd be a good idea.
Okay. Well, I didn't file it.
I can take it, if I can have this copy, or
Yeah.
take it and file it.
Yeah. Okay. Cool. Thank you.
Thank you.
Awesome, thank you.
Ciao.
See you.
All right. Strike, and then we are on number 16 is the Briggs matter, 23202811306. Good morning,
Good morning.
Nicole.
I'm Ava.
Ava, sorry. Ava
No, you're
Nicole.
totally fine.
What's
Yeah.
your middle name?
Nicole.
Come on up. I know, Ava Nicole, I was reading the wrong thing. Or I didn't read the wrong thing, but someone put your name wrong on here. Please state your full name and spell your last name for the record.
Ava Nicole Briggs, Briggs.
All right, and this is?
My mom, I'm Nicole Ciani.
Okay. Spell your last name.
Ciani.
Thank you. First, I'm sorry, I'll have you raise your right hand. Do you swear affirm to tell the truth in these proceedings today?
Yes.
Do you swear affirm to tell the truth in these proceedings today?
Yes.
Is this Dad?
Yeah.
Come on up. State your full name and spell your last name for the record.
Thomas Briggs, Briggs.
Do you swear affirm to tell the truth in these proceedings today?
I do.
All right, so we have some issues here, but the biggest issue, Ava, who, seems to be an amazing student, you have no birth certificate. It's a requirement of the statute that I have that's filed with the court, so there's no movement we can make until that happens.
Her mom has the birth certificate, and I think they just made a copy of it so we can get it provided, but I.
Okay.
I didn't know.
Well, I know, no one usually reads the
Sorry.
statute, but
Okay.
what's your, are you guys objecting to this emancipation?
No.
Mom? Ava's 17.
17.
She's going to be 18 in no time, and then she has to make
Honestly,
all these decisions on her own.
Your Honor, as a mom, girls, my life.
Yeah.
This is hard for me.
Yeah.
I'm not okay with this. However, the only reason
I understand.
that I would grant this today is so that she can be emancipated and released from her father.
Interesting.
That.
Well.
That is why. So no, I do not contest that.
Okay, so on the record, you're indicating when Ava comes back here with her birth certificate and files it, and I go through her rights, that you're saying that you agree to her emancipation.
I do.
And Dad, you agree to her emancipation.
I do.
Very good. So Ava, you're gonna have to get that stuff filed. I'll still have to go over your rights with you, so you're not gonna be able to get this done until February 2nd. So get that filed, I'll go through your rights, I'll tell you my concerns. So you can maybe hopefully address those. You didn't file any pay stubs, or I didn't see that you have a bank account or anything like that. All I saw was that you're a brilliant student, doing great. This will actually help you for college scholarships and such as well. But I need to know that you can financially take care of yourself. So you're gonna have to get something filed for that as well.
Okay.
Okay? Anything else?
What would you, as far as paperwork and stuff like that for that, I can file that with the birth certificate and whatever
I would like
information
pay
you want?
stubs because she's got a job.
Sure.
And she says she's doing a lot of nannying, so if she wants to get something, if they don't give her pay stubs, they could write something down about how much she earns with each family. And then, she needs to have a bank account.
She does.
Yeah.
Okay, good. So
What would
then,
you like for that?
Yeah,
Just
just
the-
give me a copy of her bank account with,
Okay.
yeah, okay. All right, awesome, thank you guys.
February 2nd.
Yeah,
February
wonderful
2nd.
voice, by the
You
way.
guys don't have to be here, the parents don't have to be here, but it's great if you are, because you should support her. But all I need now is all these things plus Ava.
Okay.
All right,
Thank you so much.
take care.
Keep singing. Happy holidays.
Ah,
That was great.
yeah.
I don't get a song?
No, sorry. Huh? Yeah. Number 17 and 18 is, well, no, 17. Yeah, same thing. It's the Swint and Camara. 23-3, oh my gosh. 23-3-01-15606 and 23-3-013-9306. And that's supposed to be Markgraf and Roberge. Oh,
Good morning, Your Honor. I understand Ms. Roberge might be in some other dockets still. That's what we heard this morning. I'm not sure if she's done yet.
okay, well, we'll recall that. I have to let you know that I have so little paperwork on this matter. I don't know how much I'll be helping you guys out today.
Okay, thank you.
Okay, thank you.
We'll check back.
Minor guardianship of Dinwiddle is next, Dinwiddie. 19 on the docket, 23-4-00-96906.
So we will need Dino Goyak and Sherry Farr.
There's Mr. Goyak.
Sherry Farr
morning,
had
everyone.
4 matters in Judge Cornell's docket this morning, so I don't know.
Okay.
And I can send Ms. Farr a quick text message just to let her know we're ready on this matter.
That sounds great. And then, is that Victoria that I see with the camera on? Yes.
Yes, sorry, Your Honor, I'm driving, I'm almost parked.
Yeah, you better be parked when I call the case again, okay? Awesome.
Yeah.
Recall it real quick.
Your Honor, I'm here for 15. Did something change?
15, Emma Murison. She was emancipated on 11/13.
I even called yesterday to double check everything.
Well, the matter was originally cited on for that date, was originally cited, there's a lot of confusion with this, but there was cited on for both dates, so there was 2 dates. Have you talked to her? Yeah.
I didn't get anything, besides the original paperwork.
Mm-hmm.
And that was for this date.
Oh, I'm so sorry, I did not know that. It did show proof of service. I think I showed proof of service for, let me look it up. Come on up here, sir.
Yeah, I would have showed up then.
Doesn't actually, she served on 3 different occasions. Doesn't say the dates though, but it doesn't have to. Unfortunately. All right, so why don't you talk to me about how you're feeling about this so far? Give me state your full name and spell your last name for the record.
John Murison, M-U-R-E-S-A-N.
Thank you. Do you swear to tell the truth in these proceedings today?
I do.
Okay, so your daughter came in and she asked to be emancipated. I had proof of service and then you didn't appear, but I understand that you had something for this date and there was another date as well. My issue, the thing I have here is, are you objecting to the emancipation?
I'm kind of conflicted, but I know it's going to help her out
Yeah.
in the long run.
I mean, she really needed it because she needed it for, I mean, that's why I got her in quick, because she needed it for her scholarships and financial aid.
If she would have asked, I would have said yes, but
Yeah.
she didn't ask.
Well, how do you, when do you see her?
She
Yeah.
chose.
Yeah,
a
I
different
understand.
path.
So that's where we are.
Yeah, I try to communicate, but
Well-
I don't really get responses, so.
Yeah, we'll keep trying. Kids come back around.
Yeah, right.
Yeah, okay, she's a smart kid though.
I know.
Yeah.
Very
so
smart.
Someone did a good job.
I tried.
Yeah, all right. Well, have a great holiday. Hopefully you guys have an opportunity to speak soon. Thank you. All right.
Judge, on number 12, did you want us to hang around for that? I wasn't sure what you wanted us to do.
Yeah, I got some special sets here, Mr. Brewer. Who else was I doing this for? Oh, Mr.
The Sheldon matter.
Oh, yeah, but first of all, yeah, come on up. You come up. All right. All right. The dates I have are January 3rd at 11 a.m. and 11:30, or January 10th at 11 a.m. and 11:30.
I can do January 3rd. 11:30 would be fine.
Does that work for you, sir?
That won't work.
It doesn't work for him. One of those days works for you?
One of those days that's not gonna work for me.
You're gonna have to make it work, buddy.
Can we push it out a little bit further out?
Like how far?
Like after the 20th.
After the 20th of January?
Yes.
Mr. Brewer?
Well, I mean, some of these are semi-urgent for my client, so I would, is he because of a work conflict, or he can't
Yes.
make that, or?
Yes, it is. We had a lot of downsides right now in my workplace, so I don't know, I'm gonna get hit the next
All right,
round. So.
I'm sorry to hear that, sir. How about January 24th, 11 a.m.?
That will work for me.
Yeah, and here's the problem, I'm gone the week of the 22nd to the 26th, I'm sorry, Judge.
You're gone the week of the 22nd, is that what you said?
Yeah, I'm gone the 22nd through the 26th, so
All right.
that day won't.
That sounds fine. We could do. Then you guys might as well be on my docket for February 2nd. I think that what's gonna happen is I can also order Mr. to go to your office, you guys can get this stuff done.
Yeah, I was just gonna have him confirm his email, if I could, because we emailed him November 6th, 8th, and 9th to the same email, which is Sethnoy, SETHNOY@comcast.net.
Should be the right email, yes.
Well, you gotta check it.
So-
You should see my Comcast, it has like 8,000 emails in it, I cannot check that thing.
So February 2nd, and I will email him again, and if he wants to just
You need to get
cooperate
in there,
with that
but
date.
if you're not prepared to move forward, I'm just moving forward next time. So get in there and see Mr. Brewer, okay? All right, so otherwise I'll see you guys back at February 2nd at 9 a.m. and you're gonna respond to him.
Yes.
Awesome. Have a
Thank
great
you.
holiday.
You too, thank you.
Thank you.
Yes, that would be great. All right. Oh, and then, sir, there was another special set. Sheldon Portis, is that right? That's number 1 on our docket, 53013197.
Yes.
I don't actually have, that's not a 2-hour slot, so let me see what I'll do for that. We'll start at 10:30 and get as far as we can go. 10:30 on January 3rd?
January 3rd? Okay.
Yes.
Okay, sounds good.
All right, thank you.
See you guys then.
Thank you.
Thank you, thanks for waiting, sorry I forgot about you.
It's okay. Appreciate your time.
Okay, number 20 on the docket is the guardianship of Danica Garrard, house number 23401377706. Good morning, good morning, Mr. Hahn. I know it's really weird, but you're upside down. I don't know if anyone's told you that in their courtroom.
Well, there's probably a lot of psychological reasons for that.
Okay, well, we'll stay that way.
I'm
'cause
actually also in Judge Gonzalez's courtroom at the same time, so I'm not sure why I'm upside down.
That's weird. I like it though. All right, so what we have here is, what's your name, ma'am?
Emily Wiley.
Thank you. Yeah, spell your last name.
WYLLIE.
Raise your right hand. do you swear affirm to tell the truth in this proceedings today?
Yes, Your Honor.
Very good. So, this is, we talked before. CPS took the kids from mother originally, placed them with father left them with parents, grandparents, then came and got them, pulled them out of school, CPS was called because his girlfriend had them, and then she dropped them off at another relative, then you got these kids.
Correct.
And then, I signed ex parte on October 30th, and then there was an extension on November 2nd, today's date. You did file the full petition like requested on the 8th of November. Mr. Hahn was appointed as a court visitor. He's been unable to make contact with either parent. He spoke with several collateral witnesses and family members to try to make that contact. And he used Dad's email, the last known email. Currently, I have no CPS records, Mr. Hahn. Do you know what's going on with that? Out of the home of.
I did the background checks on the. Yes, they came back clean. Did I not include that in my report?
You didn't. You mentioned something, but there wasn't. And if I could just get something, and I'll check again. Maybe it's my bad, but otherwise I'll need something. Sorry, Emily. I did not get any criminal history stuff regarding you.
Oh, I don't have any criminal history.
Did you file a watch report?
I am not aware what a watch report
I'm gonna let
is
Mr.
or
Hahn
that I
reach out to you and
needed
talk to you about that. You're gonna need to do that. Did you do your lay training?
Yes.
Did you file something with the court so we knew that you did it?
I have it here today.
Okay, great. Why don't you go ahead and file that? I didn't see that you filed anything regarding bankruptcy. Have you ever filed for bankruptcy?
No, Your Honor.
Okay. That's it. I just need your criminal history, your watch, so I have to get that done.
Okay.
Mr. Hahn, you are attesting that these parents we're not able to contact these parents. Is that accurate?
That's correct. I've tried several different ways, but I wasn't able to make contact with
All right, I'll have you raise your right hand just really quickly. Do you swear affirm to tell the truth in these proceedings today?
Yes.
Thank you. So you've indicated that you've tried every way you can to make contact. You've even asked the ex-girlfriend of Jonathan to try to serve him if possible, because she knew he was staying in a hotel at the time. Is that accurate?
Yes.
He's probably got knowledge then of this action, and he still has not participated.
Well, Your Honor, there was just a chat that just came up that said that Jonathan is in the proceeding.
Boom. Hey, how's it going? You're on mute.
Yeah, I'm here.
Thank you. State your full name and spell your last name for me.
Jonathan Garrard, Garrard.
Thank you. Raise your right hand. Do you swear affirm to tell the truth in these proceedings today?
Yes, ma'am.
Are you objecting to this guardianship?
The guardianship, no. The restraining order, yes.
Okay. So that's great. And we can talk about the restraining order, but we're probably not going to do a whole lot of that, talking about that today. Do you understand why there is was a request for a restraining order?
Not completely, no, because I have no violent history towards them or my children.
Okay.
The CPS case that they were referring to, I was the one that actually called them.
Yeah.
Trying to get housing.
Yeah. No, Jonathan. So first of all, I want to congratulate you for being a good dad and not objecting to this guardianship, because you have not had the ability, in the recent, to parent. And so the best thing a parent can do is to make sure that the kids are taken care of. So thank you for being that kind of dad. Second,
I completely agree with that.
yeah. Second, the reason why the restraining order was put in place is because you had pulled them from the grandparents at one point and took them out of school and everything, and then they were in a really difficult situation. So there was a fear that since you weren't participating in these proceedings, that you would just go ahead and do that again, because you could, unless we did this restraining order. Do you understand?
Yes, I do.
Okay. So it sounds like, though, now, since you're participating, that we might not need that restraining order, but it's not something I'm going to fully address today. But what I would say is, are you wanting to visit the kids or talk to the kids?
I would like to do either one. I know that they're down in Vancouver and I'm up north, so it's kind of hard to physically see them, but I would like to at least be able to Zoom call or talk to them on the phone maybe 2 or 3 times a week, whatever's available for them and their schedule.
I think as long as it's a supervised call, that's fine.
Okay, so Jonathan, right now, the problem is you haven't seen the kids for a while, right?
Correct. I have not been able to because I haven't had stable housing
I
or
understand, I'm
employment.
not judging you at all. I'm just letting you know these are kids, and so when kids haven't seen somebody for a while, and the last time they saw the person, there was a lot of chaos. It makes it really difficult for them. They gave some pretty good statements to Mr. Hahn about what kind of had been going on for them in the past and how much trauma it caused them. These are kids, they don't use those words like trauma. But they were really talking about, I mean, I think it would make you kind of sad to hear what they had to say. It doesn't mean that you're not going to get back there. It just means they might be a little freaked out if they hear from you right now.
Which I completely understand, yes.
Yeah, I love that. Thank you so much. So what we need to do is try to get things started. And so what Auntie will do is she's going to go ahead and she'll set up some time with you to, talk to the kids through the holidays very briefly, because it's going to be rock their world. And she'll be present when that happens, and you'll want that, because you'll want that type of support, so that when the kids are feeling weird, they'll have someone there that they feel comfortable with. And after the holiday, we'll get back on this like this via Zoom, and we'll talk about what we do to move forward, okay?
Okay.
That's awesome. Great. So I'm going to put you guys back on for February 9th at 9 a.m. and then we'll talk about like what a visitation type schedule can look like for you, which is Zoom. When I say visitation, until we get to the place that things have changed a little bit. And since you are consenting now to the guardianship, I'm going to go ahead and sign off on another extension. I think we could do the full guardianship at the next hearing, though.
Okay.
Okay? And then, Jonathan, have you heard from Mom at all?
No, I've not heard from her in years.
Yeah.
And as far as I know, neither have the kids or most of the family.
Yeah, nobody's.
No, none of us have heard from her in years.
Okay, I just wanted to get that on the record as well. All right, so I'll see you guys back here January 9th. Off docket, I'll do a February 9th. Thank you.
I wrote down February.
Order extending the current emergency minor guardianship, and then the next hearing will enter the final guardianship. Now, it's not final, just so you know, Jonathan. It's not, in nature, they're not final. They're temporary. When a parent gets themselves together, they have a right to, if they want to. Although I know Auntie was really hoping to keep them in a stable housing until they're 18. So, and Mr. Hahn, you can appear if you'd like, but you don't need to appear for the next hearing, because I've got all your information.
Okay, so I'm dismissed?
You are dismissed unless we sign you back up again.
Okay, all right, thank you.
You did a great job. Thank you. Thanks, everyone. Have a great holiday.
I have a very quick
Uh-oh,
question.
yeah.
In the EMG paperwork, it states that I am the one to claim them on my
Yes.
taxes. However, I did not have them for at least 6 months of this year. My parents did. Are they able to claim them on their 2023
If you'd like
taxes?
to have them do that, otherwise you can't still.
Okay.
Yeah, you're not gonna get, it's gonna be expensive.
Yeah, okay.
Okay.
Oh, yeah, I mean,
Yeah, okay.
Yeah.
Whichever way you guys decide you wanna do it.
I just wanna make sure that they wouldn't be doing anything illegal.
No, not if you're letting them.
Okay.
Yeah.
All
okay.
right, thank you, Your Honor.
Also regarding that, I was contacted by their other aunt Kayla, and she was asking to claim them, considering she's had them back and forth between her and her parents for the majority of the year.
She did
And
not. She had them for about 2.5 months.
It's okay, Mr. Jonathan, what I'd like to let you know is she's not here, and so she's not party to this, and she hasn't asked this court, so I won't be considering that right now.
Okay, not a problem. I just wanted to bring it up.
Thank you so much, I appreciate that information. You guys have a great holiday.
Thank you so much.
You too, thank you.
And number 19, I believe everyone's here.
Okay, 19, the Dinwiddie.
Jerry Farr.
Good morning, Your Honor. I wanted to apologize. I was dropping my daughter off at school.
Okay, no worries. Good morning, Ms. Farr, Mr. Gojek.
Yes, good morning, Your Honor. Can you hear me?
Yes.
Good morning.
All right, so we're here because we needed to sign, we thought we were gonna be entering a final guardianship probably at this time, since enough investigation had been done, both parents had consented, And we got a brief investigation done by Ms. Farr. But then I received a declaration from from Victoria. I'll just use your first name if you don't mind. And she's now opposing the guardianship. And Mr. Gojak, I understand, is wanting to withdraw. Is that accurate?
That is correct, Your Honor. At this point, there's been a breakdown in communication between me and Victoria, and she has requested new counsel, which I think would be appropriate in this case.
All right, you are excused, sir. Thank you so much.
Thank you, Your Honor.
So, Victoria, just so you understand, our statute gives you a right to have an attorney. I will appoint another attorney on your behalf, but it'll be the last one I appoint for you. So if you can't get along with the next attorney, probably because you don't like their advice, then
Your Honor.
you'll be on your own. I'm going to go ahead and set this matter for trial now so that we get a date on the books for such. I want you to really try to read through the materials, Victoria, and kind of see what kind of information is in there. I know you feel like everyone slandered you, but that would include the Tigard Police Department as well, who did an investigation on your behavior as well. That included your son. That was horrific and traumatizing to me even to read. So, if you to choose to move forward for a trial in that situation, that's going to be difficult. I want you to understand that this court has to make decisions that are in the best interest of the child. And I'm hoping that when we have these guardianships, my biggest hope is that parents that have some issues that they need to deal with understand that a guardianship may be what's necessary for a period of time until they can deal with those issues. And from your behavior in the recent, doesn't look like that's something that's been done. So you'll have a chance to prove me wrong on that. I'm excited to get that information. So I'm going to have Ms. McCann do a extension and a notice order setting trial.
Okay.
Yes, sir.
Are we allowed to talk about this matter?
It's caused a rift in the family. These are not parties, but.
Oh.
Well, actually, this is the mother of Victoria.
Uh-huh.
And what has happened is that up until this original motion was put.
Come up here, sir.
Mm-hmm.
Please state your full name and spell your last name for the record.
Mark Derbyshire, Derbyshire.
Do you swear affirm to tell the truth these proceedings today?
I do.
And how are you related to these people?
I am Nina's fiance.
Okay, talk to me. What's going on here?
So what I have observed is that over the last year or so, that Nina has been spending time with Bryson. Everything was going along fine until, I want to say it was August, that we were told that this was necessary so that Cindy could get a passport to take Bryson to Canada and to start this. And what I have witnessed is that all of this whole thing has drawn a wedge in between all of the family members. I don't know all of Victoria's past.
Yeah.
What I can see though is that Bryson was having a wonderful relationship with Nina.
Yeah.
And that there was difficulties with Victoria talking to Bryson. And what I've witnessed since all of this has started is that all of a sudden Bryson has been totally taken away from everybody that he's known.
Yeah.
And there's been a lot of just bad talking and a lot of talking in front of Bryson of what is happening. And you know, I know there's been some bad things. I've heard some stories. But what I see as an outsider is that you have a child who has a mother that loves him, has a grandmother that loves him, and has a great-grandmother that loves him. But for some reason, all of a sudden, there is this big, huge wedge that is being driven in between all of these family members. I've personally taken Bryson and Nina with me to go camping. We've gone to a bunch of different activities. Nina's been heavily involved in his life. And all of a sudden, it's like the door's been slammed. And Bryson has been told a lot of different things. I hear about the phone calls that Victoria tries to make, and those phone calls are shut down. And from my understanding, your orders were is that Bryson and his mom would have a phone conversation that would be private and not interrupted, but in the background, you hear Cindy saying, hang up the phone. You know, it's really disturbing. I have an older son.
Yeah.
And like I said,
So
I don't
have you
know.
been participating in these phone calls and heard this? Because we do have see what we have, see Ms. Farr? Did you have an opportunity to speak with Ms. Farr?
I've been on the outside
Okay.
watching and looking
Let me
and
finish talking real quick.
okay.
She's called the court visitor in this case, so I don't even know why we appointed a court visitor, I'm glad we did. Because usually when we have consent, we don't have to go through all that process, but thank goodness we did. So this is a neutral party that comes in and talks to everybody, including Bryson. We like to have a particular type of person that talks to the kids, because we don't let them come into court, we don't want them to see all this, right?
Absolutely.
Well, the stuff that's happening in the phone call sounds really awful, and that's coming from Bryson.
Okay.
So, he's needing his great-grandma to intervene for him, because things are really bad in those phone calls.
Okay.
And then it's not healthy for him. I hope great-grandma's not talking about this stuff in front of Bryson. I hope that's the case. It happens all the time in my family law cases, which is really irritating. So it's really damaging to the kids if that's happening. So I hope if she's doing that, she makes sure there's only adults that are around when she has that. I'm sure she needs an outlet, because some of the stuff that we've learned is not good at all.
Sure.
Okay. So I don't want there to be a wedge, because it seemed like you said in the beginning, Grandma was helpful and assisting. This guardianship's necessary for many more reasons than besides just a passport, because we've got medical and education, all these other issues that great-grandma has to deal with, right?
Correct.
But what I can tell you is, if you just could read just what Bryson said, I think that your heart would be a little bit broken.
Well, my heart is broken. My heart is very broken, because I've witnessed it, but I also witnessed that when he's outside and he's outside of that situation,
Yeah.
I feel like there's a lot of coaching going on.
Yeah.
And, you know, I think there's a lot of damage that's being done
Yeah.
by Cindy not allowing Bryson to spend time with Nina.
Well, maybe you should think about what's going on between Nina and Victoria, and what Nina's doing that's brought, what Victoria's doing that's made Nina start responding the way that she's responding to great-grandma. And the things that Nina, even in her letter, is saying, how she's pulling her mom into it now, and how things were going well, but now her mom has to take her side, and that's a hard side to take when you read all the incidents of what's occurred here.
I have read through all
Okay.
of those, and,
Yeah.
and here's my understanding of it, is some of these things were from a long time ago, some of them and that's.
Okay, well.
I mean, I know there's some.
So what I want to talk to you about,
But I
I
think it
appreciate
was-
you giving me information, and it feels like you've been pretty somewhat neutral here. But what I'll tell you is, I've got a 2021, it's 2023 police report.
Yep.
That if CPS were to get involved in this case, Victoria probably wouldn't see her child again.
Okay.
Okay, so, the thing about guardianships that are so, stop talking, the things about guardianships that are so lovely is because they prevent CPS from making a determination where that mother doesn't see their child again.
Yep.
So that parent has an opportunity to get themselves in order.
Okay.
But it doesn't help if people are enabling them and letting them feel that they are the victim in the situation, when really here Bryson's the victim.
Sure.
So, this guardianship, the guardianship law requires that I try to repair the parent-child relationship.
That's
And
awesome.
so, first we gotta get to the place where we're stable, which was the good thing about her consenting originally, and then we can start counseling, reunification, all these types of things. But with this drama that's going on now, that's gonna be really hard for us to do, right?
It is, and I agree with that, and I've been involved in situations very similar with my ex and my son's mom.
Yeah.
One thing that I see as an outsider that might be extremely helpful is parenting classes of some sort.
Yeah.
On both sides, because I see a lot of mistakes being made.
Yeah,
There's
sure.
no doubt about that.
Sure.
But I see that the relationships that he does have, especially like with Nina.
It's gonna be sad for him not to have that relationship, but that relationship was allowed before by great-grandma, so just think about who's creating their real wedge there then. If it was happening before, if they were having the visitation, and he was having these mutual relationships, and then now, since this, all this, now all of a sudden that's not happening.
Right.
So think about why that is, and not blaming it on Cindy.
I'm not blaming anybody.
I'm just saying, there's a common denominator here. But we'll get back to that. I appreciate what you've had to say. Thank you so much. So for now, we'll do the extension. I'm gonna appoint a new attorney for Victoria. We are going to, what is the other thing I said I needed to do?
Well, reappoint Sherry Farr as guardian ad
Yes.
litem.
And
She
set a
can
trial.
then interview
No,
these people and others that, you know, and do the guardian, work of a guardian ad litem.
Yep, great.
I can submit that off docket
Yes.
with, and approving her fees as court visitor. and-
Yes,
Okay.
awesome, thank you so much. Victoria, go ahead, please.
Your permission to speak.
Sure.
Okay, so I just want to remind the court that not taken from me. I handed him over to my grandma to get him help.
Yeah.
I'm sure you read my letters,
Yeah.
and she was in contempt of court many times. My phone calls, if I could record them, you would see that our phone calls were appropriate and loving and caring. And then Cindy didn't like our conversations, and she would barge in and interrupt all the phone calls
Okay,
and
thank
start
you.
yelling and causing conflict.
Yeah, Victoria.
And then
Victoria,
my
Victoria,
nervous.
Victoria. The thing is, like, what's happening now is I've got like this docket with like 25 cases on, and you're gonna need a lot of time to explain all this information, and I want you to have that time. So we're gonna set this for trial, and then you're gonna have an opportunity to give me this information. I sure hope that's not happening, and I'm gonna ask Ms. Farr to relook into that again. And she
Well,
can
Sheriff
kind of.
Farr is
I'm not
not
done
interviewing
talking.
mom.
You're talking over me.
Sorry, it's hard
Yeah.
when it's Zoom.
I know. You're all the way in Hawaii. Ms.
Mm-hmm.
Farr, if you could think about whether or not having these Zoom phone calls recorded, and if you think that would be appropriate, then I'd like to know, because I don't find a problem with that, so we can see really what's going on. I know,
Yes,
Victoria, I know you think that she's fed Bryson all the stuff, but most of his stuff was really independently corroborated, and it's kind of sad. So.
Okay. So you know, I've been in an abusive relationship myself, and I know when you're in an abusive relationship, you side with your abuser.
Perfect.
And
All right.
I feel like
Great.
that's what-
I can't wait for you to give me this information at trial. I'm super excited for that. So.
Can I request that Cindy Ackerman gets a health evaluation and start taking parenting classes?
Thank you. I'll consider that.
So we need an extension and a trial setting and an order reappointing Sherry Farr now as guardian ad litem and approving her fees. There is an order about phone calls.
Yeah.
Twice a week, but nothing sneaky, little signs, nothing
Yeah.
pressure.
No, I mean, like, you
nothing-
guys have no idea
Yeah.
the stuff that's been happening.
Yeah.
This is what's so sad.
Well,
If you could,
it just comes to show that she comes into the door.
why are you
Comes
why
in-
are you holding up signs for your child?
I'm on the calls a lot.
Because I was asking if I could videotape the phone call, and because Cindy
Well, if
kept
you're allowing
barging
that,
in.
then you're a part of that. So, if she's holding up signs.
I was raised by that woman, and
Yeah.
I will tell you, she barges
Yes.
in those calls.
Yeah,
and
great.
she
I'm
has-
done listening to you guys for right now. I appreciate everything you're saying. I'm gonna get those phone calls recorded. We'll have Ms. Farr address that, because that's what you've asked for, Victoria. That's what your letter asked for, so that's what I wanna tell you, is I'm hearing what you're saying. So I wanna do that, so I'll have Ms. Farr figure out the way to.
I don't hear what I'm saying. She's like threatening to block me. She's constantly threatening to hang up on me. She influences my son to constantly hang up, and she starts acting hectic and crazy, and then he gets uncomfortable and the phone call has to end. I don't know what's right from wrong anymore. I don't know if I should call or if I should hang up, because it's toxic anyways. I'm freaking out over here.
Okay.
Your Honor, I do have a suggestion if the parties agree, if the court will entertain it, and that is that I can set up the Zoom calls for the Saturday morning calls and record them while they're happening.
That sounds amazing. How's that sound,
Everything
Victoria?
Perfect.
Wonderful.
What I wanted.
Great. Can't wait. All right, I'll see you guys back here. What date did I give you? Did I give you a date?
No, so trial date.
Oh yeah, you're gonna do that.
Yeah, well, so I believe Sherry Farr will need maybe till April.
Yeah.
Yeah, so
Okay.
I'll contact.
So, but Victoria, you're probably gonna wanna come back here prior to April so that we can try to see if we're gonna be able to expand some of this visitation, right?
Oh yes, can I change the time of the
Okay.
phone calls?
This is what's gonna happen right now. And I've tried to say this, so I hope you're listening to me, and I don't want you to interrupt me. I've told you all the things I'm gonna do now. Ms. Farr is gonna continue to investigate. She's going to set up the calls and she can adjust the times if necessary. She's in charge of all that. Do you understand? I'm going to appoint an attorney for you. And if that attorney thinks that you guys need to get back in front of me so we can adjust more visitation stuff, then we'll do that. Okay?
Okay.
All right. You guys have a great holiday.
Thank you, Judge.
Thank you.
My client is here.
Thank you, Your Honor.
I could see that you understood the case. I had
Yes.
prepared a summary and you didn't want to hear from me, but you already knew. All right, thank you.
Bye.
Bye.
Thank you, Your Honor.
Thank you, Your Honor. And that's my only matter. Everyone have a good rest of your day.
You too. All right.
Happy.
Who have I got left here? I've got an add-on.
If we could take that, Your Honor, I would appreciate it.
Yeah.
I've been doing Judge Gonzalez's courtroom since 9 as well.
Oh my gosh, sorry about that.
No, it's okay. It's not the first time I've been yelled at by a judge. It's just never pleasant.
Should I yell first then?
Sure.
No.
Yes, please do.
1930.
You know what? Let's start the day off great.
Yeah.
No, because I don't. I've been listening to you since last Friday, and you don't sound well, and I don't mean that
I know.
offensively.
I feel way
but
better now than I
that's
was.
why I did this, but yeah,
Yeah.
Friday was it was painful over Zoom.
Yeah, last Friday was awful, but this Friday I feel good. It sounds disgusting, but okay. That's not the right one. I had it in my hand.
This
Right
is
here.
the Layla
Layla.
Mitchell. Yeah, and
And-
I do have my client present too, if the court has any questions.
Okay. So, did you serve the parties?
Yes. We have served all of the parties and the court signed off on, I believe, November 9th or thereabouts, permission for us to try to serve mom by mail. The biological mother, Elena Mitchell, has really never been involved in this child's life.
Right.
So she's off and in the wind. We attempted multiple times over. We heard she was in Dayton. Attempted multiple times to get her served there. Our process server over on the other side of the state found out from the trailer park in Dayton that she's perhaps homeless on the streets of Walla
Yeah.
Walla. So we tried to serve her by mail, and we've received both of those certificates back.
Okay. Is Sharon and David here?
Yes.
Oh, come on up.
And they've been served as well. Everything, we send out all the letters, and we've received their response. It was filed on or about November 7th.
Oh, I don't think I did. Sorry. State your name, please.
Sharon Nelson,
Spell your last name.
Nelson.
Do you swear affirm to tell the truth this proceedings today?
I do.
Thank you.
David Nelson, Nelson.
Do you swear affirm to tell the truth this proceedings today?
I do.
Very good. So you guys are the current
Yes, we are.
guardians.
Yes.
And you understand what's happening here.
Correct.
And you're objecting, I'm assuming.
Yes.
As of your look on your faces. Okay.
Well,
Yeah. So, what will happen is that this has to be modified, turned to, what's it called? It's to go into, turn into a minor guardianship, it's currently.
It already has, just because it was the non-parental custody, unless the court wants to convert this to
You
a.
have to convert it to a guardianship.
So this may think, I think it's probably court order that we would have to convert that. So if the court wants me to do an opt-out in
Yes.
order to convert that, we absolutely will.
Yeah, so you'll do an order to convert that, it'll get its own new cause number, and then the
Correct.
two will be merged.
Okay.
So you understand what's happening here?
Not
Okay.
exactly.
So the statute changed, you guys had third-party custody, right?
Right.
And there's no such thing as that anymore. You
Okay.
guys, the only reason why yours is still here is because you were in final orders, anyone in temporary orders was dismissed, and then this new statute came on, this minor guardianship, which you've watched the drama around that. This new statute's different, so if anyone asks to convert, they automatically get to convert it, they get to convert it to modify it or to dismiss it, right? So in this case, it'll be converted to modify or dismiss, that's what's being asked. And this statute's different because it really, contemplates the parents being able to parent again, unlike the other one. So, in the third-party guardianships, a lot of times people can just keep their kids away from them for the rest of the time. Now you can't do that, right? So now they contemplate the parents will have a relationship with the child if they want to, and they're willing and able. So, that's kind of a wake-up call for people who have third-party guardianships. That means if you're angry and you don't want them to have that custody,
Right.
you better rethink it and start thinking about what visitation is going to look like, because that's what this court's going to do, because it's required of me by statute to start visitation with father and to allow him to get him back to where he needs to be a father if he wants to be a father, right?
well, he's had visitations.
What's visitation look like right now?
He gets her every weekend and every holiday.
Oh, that's wonderful.
He actually, just as an update, it's her last day before winter break at school, and then he will have her through the 1st.
Wonderful.
So that's why this is kind of critical to get this before the court, because natural breaks is when the court tends to want to, should the court grant this, have her start at the new school if she's placed with dad. If that's not gonna happen right now, our request today would be that, one, Layla be appointed an attorney, because she is over the age of 12.
Yes.
So we would want to have her to have an attorney through this
So
process.
we'll appoint an attorney for Layla.
But we have a couple of questions.
Give me a second, let her finish
Okay.
talking.
So the other thing that I was going to ask is that we set this on for a trial date. Obviously, I'm gonna have a motion to convert this to the court so that we'll be able to convert that. And then once I know who the attorney is, then I can go ahead and put in that order so that that's available for Layla going forward.
Okay, sounds good. We'll appoint an attorney, once we have your order to convert. And then,
You'll have that by this afternoon.
wonderful, thank
I'll go
you.
right back to my office to do that after I see Judge Gonzalez.
Yeah. Okay, and go ahead.
So, the father has not stated he has a girlfriend that is currently pregnant.
Mm-hmm.
So, there's the current concern regarding that, there's no mention of that.
Mm-hmm.
And then, when there's we understand when it says living in the household, the background check.
Mm-hmm.
He has older children
Mm-hmm.
that come and go and do live off and on.
Mm-hmm.
The girlfriend and him have talked about living with each other.
Mm-hmm.
There's no background check regarding her.
Mm-hmm.
And then Layla, when she read the last document that was mailed to us, she stated that she did not say that she wanted to live with her father.
Okay, so I'm gonna
Layla
stop you,
also
stop. There's a couple of things here. Number one, is Layla here?
Yes.
Okay, Layla, come on up.
And as a party, Your Honor, we do provide Layla also with copies of these things, which is why an attorney would be appropriate.
Hi, how are you?
Good.
Could you state your full name and spell your last name for the record?
No,
No.
just your first and last.
Layla Mitchell, M-I-T-C-H-E-L-L.
Raise your right hand. Do you swear affirm to tell the truth in these proceedings today? Very good. So you're old enough to be a party, although you really don't look like you're old enough to be a party. And so you have a right to be here at every hearing. You don't have to be here at every hearing. I wouldn't suggest it's the best thing for you to do either. You have a right to read every document. You have a right to tell somebody you don't want to read those documents, which I suggest you do, but you're probably not going to do that because my daughter wouldn't do it either. But it's not very healthy. So I'll say that first. I'm going to appoint an attorney for you. Hopefully that attorney is going to go ahead and talk to you about these same issues that I've raised because you're old enough to have your own attorney. Then you'll be able to speak freely. I'm also going to appoint a court visitor just because they're a little bit different. Court visitors better talking to kids. And then I want you to understand that your information you share with your attorney will be confidential unless you want it to otherwise be. The information that you share with the court visitor won't necessarily be confidential. Those are the difference between the two. You're her auntie?
We're not blood related.
We're not blood related, but she calls.
Auntie?
Yeah.
Auntie, and she's not going to be able to speak on your behalf, and nor would dad or dad's attorney or uncle, right? You speak for yourself, you're old enough to, and no one else gets to speak on your behalf besides the attorney and the court visitor. So just now Auntie was about to tell me something, and I'm not going to let her tell me because those are, if you have something you want me to hear today, then you can tell me. Do you have any concerns that you want me to address today? Are you excited for winter break? Where do you go to school?
Rochester Middle School.
Rochester?
We live up north.
Ah, interesting. Do you like it up there? Yeah. Cool. What grade are you in? 7th grade. That's a tough one. Ugh. Middle school.
Yeah.
All right. Well, so what's happening now, and you don't ever have to come back here again if you don't want to, but you can, is that everything's kind of status quo. Do you know what that means, right? Status quo means everything stays the same. So everything will be the same for a while until this court does something different. So you'll just be on the same visitation schedule, just have the same living situation, be with your friends at the same school, doing all the things that you're doing. I will also tell you it is very unlikely, even if that were to change, that I would have you go to a different school this year. So don't start stressing about something like that, okay? All right. Anything
Does the
else?
court want us to come back for just a status or a review on, say, February 9th? I'm gonna meet
Sounds
before you
great.
anyway on a readiness for a
Perfect.
termination. So
Yep.
I think that way, can we just
You
make sure
guys can
everything's
appear via Zoom, all three of you, if that's a Friday. I don't know if it's the weekend that you'll be coming to bring her down or how that works or anything
We'll
like
figure
that.
that out.
You guys figure it out, but you're available, you're able to come via Zoom. It doesn't won't take away from anything.
So what's the next process that we're doing now?
So she's converting, they'll do paperwork making this a minor guardianship. Go ahead and look at the minor guardianship statute and kind of read through
Sure.
it, so you can understand kind of what the difference is between the two and the direction that we'll be going,
Okay.
right? How long have you had Layla?
Almost 4 years.
4 years.
Yeah, that's a
But
long
we-
time, so this is not something that flips like that, right? Just understand.
Sure.
Okay, so, just read through it, then if you have questions, you can ask them next time.
Okay. Sounds good.
All right, see you guys back here February 9th, happy holidays.
Yep.
CPS records, are we gonna, CPS?
Okay, so, Ms. Bosch, I would like to make sure that, anyone who is living in the house or frequents the house, we do a whole CPS background check on that.
It's already
And-
been provided,
Great.
it's just that I can tell you that CPS right now, their discovery unit is a
Slow.
little bit slow.
Well, if you do the electronic one, it usually pops out pretty fast. I don't know if you've seen that portal.
Still not having great, and also they don't give me access
When
to
we get a
it.
court, when we get a court visitor, they'll be able to get it
Perfect.
much faster. Also, on the watch report, I'd like the watch report of both dad and if he's got adult children that come into the home and as well as the
We've
girls.
provided that as well.
Okay.
Okay, thanks, so that's already done.
Sounds like so you're saying they didn't do it?
No.
No, they did
Nope.
not.
Well, you guys will have an
Provide the watch
opportunity to
report.
demonstrate that when I see you February 9th. Yes, sir.
Your Honor, can I just get some clarification, so I have no issue
This is
with
my
any
client, Mr.
background
Porter.
checks?
I'm up here first. State your full name and spell your last name.
Tyzak Fortner, Fortner.
Very good. Do you swear or affirm to tell the truth in these proceedings today?
I do.
Good.
So I have no issue with any background checks or anything being done. In terms of my adult children, they're adult children and they
Yeah.
come by my house.
They just come by your house,
Yeah.
yeah. I mean,
And-
normally we wouldn't check that stuff,
And
but,
it's, it's scheduled and I mean, they don't.
yeah.
They live their own lives and they make their own decisions and I don't support most of their decisions.
Yeah.
So
I
as
got
far
some
as
of
them
those.
getting background checks, then I don't see that as necessary. In terms of my fiance, so we live in two completely separate houses.
Yeah,
We
but-
do spend a lot of time
Yeah.
together, so, if
Let's
that's.
go ahead and
If we
do
need
that.
to do that,
We'll do
fiance's
that with
fine,
the
but-
fiance, but not
yeah.
the children. And I
Thank
want you to understand something. You've been doing this process with visitation and everything for quite some time, and now you're asking about,
We've had concerns,
I know,
but
but they're not really, but you didn't come to the court and say you've had these concerns before now. So it seems a little, we'll talk about it later. So we'll address that issue if we have to later. For the fiance, I'll make sure we do all the other stuff.
There
Go ahead,
has
put that in
been
the
some
bag.
new stuff that's come up from Layla that we've heard, which is concerning that we didn't necessarily know about. So that's kind of another thing that's a little bit of an issue for us. That's kind of what brought on this whole idea of we would like better background checks.
Mhm.
We've been denied like some access to CPS just because they don't give it to us. And that's why we would like those records brought forward so
So
that you
CPS
have
is
those.
only gonna check people who are in the, if there's been CPS history in the house. They're not-
they came to our house
Yeah.
because when she first came to us, CPS came to his house in Woodland.
Mhm.
And then there was an incident in a winter time.
What was your name, first name again, I'm sorry?
Sharon.
Sharon, listen, we're not gonna deal with a whole bunch of stuff right now, I'm gonna kinda make my rulings on those issues.
Right.
One of the things I want to caution you about is if to raise something that happened 4 years ago compared to where someone is now. That's really what the court's looking at, right?
Right.
So, if CPS came to your house 4 years ago, I would imagine they would, because there was a lot of stuff going on, which
Sure.
is why you guys have her. But when we see somebody who's really worked really hard about moving on, we don't continue to throw stuff from the past at them.
Oh, we're not. We're just trying to show
Your concern.
concerns and not everything that he was stating.
Well, you're gonna have an
Was
opportunity to talk to me about all of
And
this.
they had an opportunity to respond, and so, yeah, that's the time and place to do that. So I
Yeah.
do appreciate what the court has ordered today, and we'll make sure that all of that is remedied by this afternoon.
Yeah, so February 9th is when we're gonna see each other again. If there's specific things you want me to look at, please put it down and file it and address it and get a copy to me, so everyone in the court knows that we're gonna address those specific issues on that day.
Sure.
Today, the only issue before the court was the conversion, right? That's all we're doing, and I've kind of fast-tracked some other things, we're getting the attorneys on board, and we'll make sure we get these
So-
background checks.
So when we file that, is there a certain file? What file?
Ms. Bosch is gonna send you all the information, so you'll have the new
Okay.
cause number once she does that.
You
And
will,
once-
you guys will have that, we'll do the same thing. Do you guys have an email that you would rather accept things on? Is that easier, or do you want it just mailed to you? It doesn't matter to me.
Can you do both? Because sometimes when I get the email, they don't
Open.
always come to
If
me.
you're happy to give me your email address, I'd be happy to do
I'm
whatever
gonna let you guys
prefer.
do that off docket.
Okay.
Peace
That
and
would
hair
be-
grease. I'll see you back here February 9th.
Thank you.
17 and 18? Thank you.
No, it's the one that I usually both get.
Went and Camara. Oh, there we go. All right, Miss Margraf, and then do we have Miss Roberge? And so, let me tell you guys what paperwork I actually have. This is my stack that I received. It's this little teeny stack here. That's it. That's all I have.
Okay, if I can explain, I think I know what's going on here. Is we communicated with court.
Pardon?
We were the office was instructed by the court to submit a letter including only the agreed order on consolidation, and then referenced a series of submissions that were on base, and I think there might have been some miscommunication. Perhaps we were supposed to provide paper copies from the filings which occurred in October under the old case 23-3-01156-06.
Okay, why don't you guys tell me what I'm supposed to be doing today?
We were asking for the court to adopt our proposed parenting plan, the worksheets, our motion for temporary family law order.
And Ms.
And Your Honor,
Roberge,
of
what's
course,
your...
we would object because we maintain this is a little premature. This is a very complicated case. It's definitely a he said, she said. Dad maintains that the client, my client, went
Guys,
into
you
a
guys move
manic
out of the
session
courtroom.
and threw herself.
Go ahead, sorry.
Sorry. But, threw herself down. My client maintains very strongly he pushed her. This he said, she said is at issue. It formulates the case. We are very fortunate. We have a very good GAL, Amy Paul, who is going to be looking into these details far more carefully than the court would ever have time. We're saying that a parenting plan really shouldn't be put in place until we hear from the GAL. I'd like to say that my client has made great strides. She's in mental health court, and she is getting things more stable. But again, this is the things that the court
Ms.
wants
Roberge,
to
I'm gonna
hear.
cut you off here a little bit. So, are you saying there shouldn't be temporary orders in place? They're asking for temporary orders, right?
Correct, Your Honor.
So you're saying in a case where we appoint a GAL, we don't even have temporary orders? I'm confused.
That is correct, Your Honor. I
Had
think
any
it has to
orders,
do
Your
with...
Honor, I'm sorry, if we had any orders, we would like to turn them just interim, so that you would know that they're just very temporary, not even less than temporary, that we really need this GAL report. We need the mental health report.
Okay, I've heard you say that already. I'm really just trying to hone down. Are you objecting to the temporary orders being put in place?
Well, yes, Your Honor, we don't feel that the father should be the primary parent. We think the mother should have, at least a 50-50 ruling. But of course, I don't think the GAL can make a recommendation at this point because she hasn't had enough time to
What's
fully
happening right now?
investigate.
What's happening with the children right now?
The children are with their father. They haven't seen the mother since, I believe, late June.
And then-
after a serious incident.
Okay, so Ms. Roberge is asking for it to stay that way. Is that right?
Apparently so. And I'd like to note for the record, we're requesting that the court enter a temporary parenting plan. We spent quite a lot of time on. Again, obviously it is temporary, but we've tried to put together a phased-in approach with various markers for responsibility and accountability for Ms. Carter to make sure the children stay safe.
Okay, but
And
Ms. Roberge is
I'm
just
not
asking
clear
for
on why.
status quo, so I guess we'll just leave it at that. I don't know why you'd be arguing against that. That's
Sounds
weird.
fine by me if we want to wait.
Okay.
Yeah. Okay.
Makes no sense. All right. Then I guess I'll just let you guys, I don't have a bunch of information in front of me. I'll wait for Ms. Turnbull to go ahead and get her investigation started. Maybe you guys can make sure I have all the paperwork that I'm supposed to be reviewing for this. And then I'll put you guys back on for February 9th. And I guess we'll just do status quo till then.
Right, well, Your Honor, wait, can I clarify though? I do apologize. I think there was a miscommunication with our office in the court. Going forward, when we're asked to reference submissions, do we also submit those with the fresh pleadings?
I have to say, I think I was pretty confused by the case itself. So I can go ahead, if you just give me a letter directing my attention to everything, I'll use, what is it called? The computer?
Basically, that was the letter that we sent just a few days ago. It
Yeah.
had just the consolidation and then submission numbers, and I think
Yeah, I
there
got
might
it
have been.
now. Great, I'll do
Okay.
that. I'll use that to prepare for the next hearing. Thank you so much.
Great. Thank you so much, Your Honor.
February 9th.
Thank you, Your Honor.
Bye.
Happy holidays, everyone.
Yeah.
Yeah, same to you.
Huh?
Bye-bye.
Items 5 and 6.
Okay, 5 and 6. Are we going back to leave? Is that what that was? And who else were we waiting for you guys?
Dr. Hahn.
Mr. Hahn. Yay.
Who's upright.
Okay, so again, we have a trial scheduled for January 9th.
Correct.
What were you guys saying again? You wanted to negotiate?
Oh, I had submitted a parenting plan, which she rejected, so I guess we're going to trial.
I'm saying I would like the court to adopt Mr. Hahn's suggestion from his guardian ad litem report.
And you're saying that you want something different than what Mr. Hahn is saying.
Correct, that's the one I submitted.
How much difference is it?
He has asked for every other weekend and Wednesday nights.
Uh-huh.
Due to how far apart we live, I think Wednesday night is not good for either of us.
Yeah.
I'd like to stick with just the 3 weekends a month that we currently have, which is very similar, time-wise.
Okay, so, and you don't like the 3 weekends a month because?
I think every other weekend is a little more fair, especially for Gabriel. He's very active in sports and has been in the same school district for almost 8 years.
Yeah.
So he would like to have a little bit more time, not every weekend.
Yeah, I understand that.
At his father's.
So Dad, what do you think about that?
I think I submitted that he spends, I think, 26 days a month at his home with his friends.
Okay, so I know, and I read that part, and we're gonna go to trial and talk about this, but the thing that's hard for me, because how old's Gabriel now?
13, he'll be 14 in
13 years
March.
old. And kids don't want to go leave their friends in their sports every weekend, because this is the age where they get super involved in all of those things, and you want them to have those strong relationships. And I know it kind of comes at your expense, comes at her expense too, because when she's home, he's out of the house, spending time with his friends and doing his sports. That's what happens when we're parents. They have to grow into themselves. So we'll set it for trial, because I want you to have an opportunity to think about this, but you're going to be shooting yourself in the foot soon, because Gabriel's going to be mad that he's not doing these things,
Well,
right?
I'm available to bring him to any sporting events. That's one of the reasons I want the restraining orders dropped,
Uh-huh.
is I'm afraid that if there's a confrontation when I bring him to a sporting event, it would be used against me.
Okay, so we're going to maintain, what's status quo right now?
For visitation?
Yeah.
Is just 3 weekends a month revolving around Mr. Leaf's trail schedule.
Okay, so we're gonna do every other week. We're gonna adopt Mr. Hahn's, but it's temporary orders, because I want to, so we'll do that. Someone's have to write that up for me, and then you guys are gonna get in contact. You're gonna do a notice to set trial on this issue, so we can just get it done. And
So our
resolved.
trial's already been set with you
Oh,
for January 9th.
that's right. What are we doing?
Yes.
So we'll just stay.
That's why
satisfied.
I was confused, because I was under the impression that we were coming in here for the readiness
Oh yeah,
hearing.
but we had the contempt,
And
which
then
is
the
really
contempt,
weird.
yeah, so,
Um,
the contempt that may I speak, sorry?
Yeah.
The contempt that
I got this already. I remember now. So, you're mad because she wasn't there on Friday, and she's upset because you didn't show up, you didn't give notification when you weren't gonna be present for the last other weekend.
Screenshot of a text message from that day.
Okay,
From
well,
11 minutes before drop-off point, when I had asked 3 times prior of the 3 prior visits that either needed to be accommodated
do you,
because
is
of a
this,
vacation
so do you
or a
understand,
drill.
are you being serious about this with the 11 minutes before when you haven't even shown, but that's, I mean, are you serious like that? Do you think that you guys are, I'm confused why you think that's appropriate?
Well, it's every weekend unless I say otherwise.
Uh-huh,
that
and so
I'm not
when do
in
you get
town.
to say otherwise?
I don't know.
Oh, so just like 5 minutes before is fine?
I don't know.
No, it's not. That's not nice to Gabriel. It's not nice to the person who's taking Gabriel. I don't even know why you think that would be okay. Okay, so no one's in contempt. We're gonna set up some better rules on the 9th so we can have an understanding of how much notice somebody gets. And, you know.
Yeah, the court has ordered him to provide drill schedules in
I saw
quarterly
that.
advance, yeah,
Yes.
and I've only gotten that
2.
twice, and that
I
was
saw that. I
earlier
remember
this
that.
year, and
Yeah,
then
yeah.
most recently, as I kept asking.
Mr. Leaf, I don't know what you're doing with this. I think you are a very loving father and you want to spend time with your son, but you're expecting everybody to kind of just accommodate you, and that's not fair. So, I'll see you guys on the 9th and we'll address this some more. You guys' exhibit list, I wrote this down. Where did I write it? All right, your exhibit lists and witness lists will be due on December 22nd. Tiffany's, your list will be identified 1 to 99. And Harrison, what do your friends call you?
Harrison.
Harrison, okay, I like that name. Anyways, Harrison, yours will be 100 to 199. And then your exhibits and your trial brief will be due on January 4th.
Okay.
When I say due, I mean you'll get a copy of all those things to me, to each other, filed with the clerk's office, and to Mr. Hahn because he's a party.
Okay, and is electronic service acceptable for everybody?
Not for me, and not the clerk's office, obviously.
Okay, yeah, that would be filed here.
Is it okay for you?
Yes.
And so you guys can exchange that way. Mr. Hahn, it's okay if they get your exhibits to you electronically?
Absolutely.
Perfect.
Your Honor, have
So
you read
how
my
do,
report?
sorry.
Go ahead.
Did you read my guardian ad litem
I did.
report? Does that need to be an exhibit?
Can one of the parties make sure that's one of the exhibits?
I put it in the paperwork I filed with you,
I know.
for this today,
I
but
know.
yes, I will make sure
Okay.
that's an exhibit.
Great, one of the parties will put it in there. Thank you. Anything else?
So I don't particularly have a problem with him going to sporting events, if he wants to go to those. If we just could communicate and I just won't go to those ones,
Yeah.
is fine with me.
Great. I have another case like that where they chose, they go through the schedule early on
Sure.
and they check off which one's gonna go to what, so you
Yeah,
guys can get that.
and I'm fine with that, cause he's gonna have that starting up, and that will start a little prior to January 9th. I had also sent an email last night that he's doing tryouts right now. Practice does not get done until 6 for that this evening. I had offered for Mr. Leaf to pick him up directly over at the school, or we would have to push our time until 7 o'clock this evening to meet.
And his response was?
There was no response that I've been
I
able
got
to see
it
this morning.
on the way
Okay,
in this
so
morning.
what's your
I read it.
response?
7 o'clock at the meeting place is good.
So you're gonna pick him up or she's gonna bring him?
We're gonna meet at our
Okay.
normal meeting spot.
Alright, there we go.
All right.
Cool. I'll see you guys on the 9th.
Okay, and then I did have one more question. For drop-off and pickups, Mr. Leaf refuses to let it be anybody other
That's
than
not a thing.
myself.
That's not a thing.
Meaning I can,
Anybody in the world that's safe or whatever, unless he can bring up some other reason, either one of you. I don't understand that. Do
That's
not-
my only question with that, Your Honor, is people that I do not know are there.
You don't have to know them. Your son does.
Okay.
Okay. All right. We good?
yes ma'am?
Bye. See you guys on the 9th.
Thank you.
Number 7. And then we have Gruber still.
Could I get you just to check, I understand. that
She's
there-
not here. I don't understand because she responded and said she wanted to continue, so we told her no.
Right,
And then she filed responsive stuff.
and I know we're making Ms. Moreno wait on her motion.
Yeah, so come on up here, please, real quick. Let's just,
What I would propose is.
I'm confused. Did you guys try to reach out to her? I cannot imagine her not being here.
No, I've been in touch with the office and we've been watching this, but we haven't, we haven't reached out to her, so.
Okay.
So what I propose is, this has been pending since July 25th when we filed our motion for adequate cause and a series of other things. And so what I propose is, I will prepare an order reflecting what it is we've requested and then present that to you today off docket. And then as far as the guardian ad litem's fees, we certainly have no objection to that. Our position is, though, that should not be our responsibility.
None of them.
None of the fees, given the circumstances. I did read this.
I did, okay, so let me stop really quick.
Sure.
So this is number 7 on our docket. I read through the materials. You guys are requesting she pay 100% of the GAL fees.
Yes.
She is requesting that it either be proportional share. Any fees that have come since our last hearing should all be on her. I will make that order in place. I will do still proportional share, and I do understand your position, but I'm still gonna do proportional share on the stuff leading up to trial. And, because it was a benefit to you as well. I don't think we would have gotten down to the bottom of things
Right.
without it. So, that's my issue there. Obviously, she's cited the statutes, and she can go ahead and ask Ms. Moreno to do all the things that she's asked her to do, as long as she pays in advance. So she'll have to pay in advance for all those things.
Right.
I'm really disappointed that she's not here. I really wanted to address some of the issues that were raised. Let's talk about Christmas. Is that all settled?
No, I mean, as far as, my understanding is we're just gonna go off of the same stuff that Sasser had put in. So she got her, the kids over Thanksgiving, and I actually gave her the continuing weekend, because it just made sense for them to get to see her, hadn't seen her lately. So she got the entire Thanksgiving break in the weekend, and then, so now would be, they had school, the kids get off school Friday, today, and then I would have them the beginning of the, winter break, including Christmas, and then I believe, on the 26th, she would then get them for the second half of Christmas break.
Right, and do you think that's gonna get
She-
followed?
She just disagrees to it, I believe. She
Okay.
thinks that she should get the whole Christmas.
Yeah, but why is that?
I don't know.
Because I went back and looked at the parenting plan.
Yeah, I don't know.
So do we have to do something to ensure that there's no conflict there? That's my
Well,
fear.
that's what I'll do today
Okay.
with the order.
Okay.
So,
I think she knows that, that's why she's not here. I can't imagine why she's not here.
right. Well, it's interesting because we got served yesterday with a packet, and then
Yeah.
as a precaution in having dealt with her before, we checked this morning. There was a new filing that we weren't provided. Obviously doesn't comply with,
Yeah, but what was the
rules.
filing?
You know, all I saw was the one line in there, she was asking the court to issue a writ of habeas corpus. So
Do you have the kids right now?
Yes.
What would that writ be for?
I don't know.
I think she just thinks that the decisions that have been made up to this point, in her opinion, are wrong, and so.
Go ahead.
She did reply to the email yesterday that you had said that the hearing will go forward, but you will take under consideration before entering any orders that she wanted more time to respond to his material, but she responded and said, sounds good, thank you.
Well, you know, we've got to bring some finality to this, Your
Yes, we
Honor.
do.
My client, if you recall, when the children were placed with him, he continued to pay not only the private school tuition.
Right.
There was no child support ordered. And then the night before the second day of trial,
Yes, I
we
know.
heard,
And we went through all of
And
our
she had-
emails because she indicated in her filings that she had notified us.
right, and she had packed up. It wasn't a situation where she knew the night before trial,
No.
oh, I'm gonna drop it.
Yeah.
She knew weeks in advance,
Yeah.
and so there's all that expense incurred. So we're also asking for support from January through June, and then we're saying for the summer, since it was a week on, week off, no support. And then now that we're back, you know, we're in school, we're asking for
That
for-
seems very reasonable.
Right, September to the present. The wage information she provided shows that she makes $21 an hour if it's a non-prevailing wage job. So we'll just use the $21, 40 hours a week. Stan makes
She's working right now.
yeah, she's got a plumbing job, I think, up in Longview. Stan is making $55, $56 an hour, correct?
Somewhere around there.
Okay, and I've got wage stubs, and I can attach those, you know,
Yeah,
to
so
the
what, I'm sorry, what
worksheets.
was your start date for the child support
January
of last year?
of last year through June, and then we take a break for the summer, because they had equal time, and then restarted September to today's date,
We'll
going
start
forward.
at February, or January, February of last year.
Okay, so started February
February,
first
yeah,
of
February,
last year. Okay, and then I'm trying to think if there's, there was an issue, and I know Ms. Moreno had, I think, talked about it in her materials about the weekends being aligned with
Yes,
Stan's
yes,
sister.
and I'm just, she's not here, I'm granting that, we
Okay.
can talk about it again later, I'm just really confused
Right.
by the desire just to say no.
Okay, and then I think probably it would make sense.
Yes, Ms. Moreno,
I'm just looking through her email, so, Jennifer sent her an email to see if she was gonna attend. She said she thought the hearing was set for 1 o'clock.
Jeez.
She had COVID last time too.
Well, I was gonna say, on the issue of attorney's fees, I think we can hold off on that, and then I could submit a more formal motion for attorney's
With
fees.
details, yeah.
Renote it up,
Yeah.
you know, and then that way, it can be heard. So, as it goes now, I will go back, prepare an order, finding adequate cause, ordering proportionate on, GAL up through the last hearing. Determine child support based upon the numbers that I gave the court, and I'll attach
yeah, okay, go
the
ahead.
wage stubs. We'll make it effective February 1st through,
Start of summer break.
through the start of summer break, and then we'll re-up it again, beginning September to the present.
Sounds good.
And I think
And then
that's-
put the Christmas holiday in there. I
Christmas.
just have a feeling.
Okay. Have I forgotten any?
No, just, I guess where do we stand?
So when we do this flipping the weekends, she gets 2 weekends in a row first. You get it?
Yeah, I
Okay,
understand.
so that we can, this just, that make it.
So that'll start after she has 2 weekends. Okay, so I'm just thinking, this probably isn't the best time.
Yeah, not during the
To do
holidays.
it, we have to be sometime in January.
And I would have to look at the calendar, but it might work out after Christmas break,
Okay,
you know? would
Yeah,
that
you
be
figure it
something?
out, but she gets 2 weekends in a row.
Okay.
all right, and then I will bring the order down this afternoon.
All right, sounds good.
Thank you.
Thank you, Ms. Moreno, sorry for that delay. All right, is that Gruber's all we got left?
Yes.
Come on up. You're the next contestant, the last contestant.
Thank you, Your Honor.
Where did I put you guys?
Morning again. Ready?
Good morning, come on up. Please state your full name and spell your last name for the record.
Melissa Hedrick, Hedrick.
Thank you. Please raise your right hand. Do you swear or affirm to tell the truth in this proceedings today? Very good. All right, we're here for a couple of reasons today, and you did some filings. Are you ready to address your filings regarding,
The motion for a guardian ad litem or the
Yes.
recusal? No,
Yes.
because none of them came with a notice of hearing, so I briefly scanned them and put them away.
Okay. Do you understand what happened? Did you expect your motions to be heard today?
These will.
I knew that I needed to file them. Someone said something to me about filing an order with them. I'm sure you saw that I just recently had to let go of my attorney. I'm
Yes.
sorry, I'm emotional.
Okay, listen, let me slow you down. So this is just a process you didn't understand, and it makes sense that you didn't understand it. So the only issue is that she's not prepared to address your motions today, which is not that big of a deal. We'll just set it over for another date. And so the only thing that she was prepared to address.
I thought I missed the whole hearing this morning.
I know. Well, we waited for you because we saw there was a mistake in the paperwork from your attorney.
I only got the email saying that I didn't show. I didn't
Oh.
get an email saying that there was
We were
a
waiting.
mistake.
Yeah.
I just thought I missed everything.
All right. You didn't. We're here. We're here for you. So, what's happened then at this point in time is we're just here to address the Rule 60 motion. And
I
not.
did want to ask about the dismissal of a standing from Friday. That was the main reason why I wanted to keep the hearing, was because, did you see that motion?
Your motion that you just filed?
I have another one that was also filed. And I understand that there was I'm sorry, I'm shaking.
Don't worry. You just take a deep breath. We're just starting our process again.
It's hard for me not having an attorney.
I know. Yeah, that's
I'm sure you saw I had to let go of Ms. Rush, unfortunately.
Yes. Yes. Okay, I saw this. I didn't get it, I just saw it, actually this morning, because it wasn't the way that it all came in. So I want to talk to you about that. I'm pretty lenient when it comes to things like that, when people don't have an attorney. But the only issue is there has to be enough notice for, me, because you want me to read everything you've got and all your materials.
I got it in as quickly as I could.
You're fine. Listen, just listen to me real quick. And enough time for Mr. Gruber's attorney to go ahead and know that something, she has to address an issue. So there's not enough time here for us to do that. Quickly as you could, it's fine. Just means we set it over to another day where everyone has a chance to address it. So you're still gonna be heard on all this. You understand? Great. I'm not gonna make a ruling on this today. The other issue is that you don't want me to make any rulings. So we have to address that issue first, and we'll do that next time that we're together as well. Do you want me to address the Rule 60 motion right now? Seems like you might want another judge to listen to that if you're arguing that you want another judge. It's okay to want another judge too.
I do.
Yeah.
I honestly, if we're starting the whole process over from the very beginning, I'd like to just start it all fresh.
Yeah, well, we're not arguing that today because,
Actually, what I wanted to address was on Friday, the attorneys both agreed to allow Christian standing. That's what this is. I was not fully
Advised.
prepared for that. And I don't, like, I know that it was agreed on. I don't agree. And this is why.
okay, I'll read through this, but I haven't had a chance to, like I said, right?
Yeah, and so I understand that we need to have a hearing on standing.
No, we do not.
That's the argument she'll be making. So this is the other thing I want you to understand. Can I use your first name, Melissa?
That's fine.
Okay, so there's a couple of things. I want you to be able to be heard on everything that you want to be heard on. I want you to think about the reason why your attorney agreed to standing before your attorney got off the case. The fact that you don't like it doesn't mean that she didn't know that the writing was on the wall. Standing is a very...
My appeals attorney
Appellate,
and
yeah.
we have a different opinion
Okay.
on a lot of things.
Okay.
I worked with him on the appeal for over a year.
Yeah.
And so him and I had a very good understanding of what everything should look like. And to be clear, this is not why I let go of Deanna, but I will say also there were a lot of places. The problem with this law, with all of this, is that there's so much that's open to interpretation.
Right.
And I mean, like I said, I've been working with Mr. Francis, and his interpretation of the law is why we won the appeal.
You won the appeal because I didn't give you an opportunity to cross-examine Christian. That is the main reason that you won the appeal. And there was no objection, which is interesting that the court didn't require that, because normally they would, but that's why you won the appeal. The reality is, if I do all the things they told me not to do again, or the next judge, if there is a next judge, but if I made sure that you had a GAL, and I made sure that you had an opportunity to cross-examine Christian, and I came up with the same result, the Court of Appeals, they were pretty clear. Like, they wanted to make sure that I had that information before I made my decision. That was that's like, whatever your appellate attorney's telling you, the judges were really clear with us about what was happening there. Let me talk to you a little bit about something which is not gonna make counsel very happy. I hate this statute. I said it from the start. I don't think that somebody should be able to just intervene on someone else's parent-child relationship. So you think that I have an opinion when all I did was apply the law. But I made a mistake because I was a newer judge, and I should have made sure that all the T's were crossed and my I's dotted. I agree with your position.
I hope when you read this, you'll see why I don't believe that he has standing.
Okay, well, I'll go ahead and read it. We're not going to address that today.
Okay.
What I want to do is just set all of it over now, which now you've sat here all day, so I apologize for that. Do we want a special set? I think we probably want a special set.
That would be fine, Your Honor, if I can address a couple of
Yes.
procedural issues.
Yes, go ahead.
So we had the agreement on standing. You do not need to have a hearing to be for standing. You can do it off prima facie, basically. I had a proposed order. In order for Ms. Hedrick to basically set aside your ruling, we need to enter an order, and then she needs to file a CR 59, CR 60 motion, whatever she needs to do. But if we're talking about process here, and what the process needs to happen at trial, then that process applies to her as well. And I don't want to prejudice my client.
Right.
And,
So did you saw her response was, you can't say, this, the Court of Appeals says one thing, but then they can't, you're saying, okay, you're right, Court of Appeals, do what the Court of Appeals says, and now you're saying, wait, but don't do what the Court of Appeals says.
I don't understand what you mean.
Well, it's like if I don't know, I can't give you a good analogy, I'm exhausted, but,
Did you read my response, if I can address Ms. Hedrick? Were you able to read the CR 60 responsive memorandum that I provided? We gave you okay, so that maybe will help you there on the CR 60, and I'm happy to come back and argue that later. I thought today was for that though, and then we were gonna get trial dates because we were gonna do this on an expedited basis, so.
Right.
I suppose, I don't know if we're gonna do that today and try and get a trial date. And I tend to, I talked to Ms. Hedrick out in the hall, we're fine together, I mean, this is the case, but.
As far as, I mean, you saw that the Court of Appeals wanted everything vacated my understanding of the visitation was that by the 15th, it should also be vacated unless, well, my understanding was that because it was part of the, I'm sorry, my writing is so much better than trying to speak because I'm so nervous, and it's all in there. My understanding was that the visitation should have also been vacated because the best interest of the child was never found without the GAL. He should have never been given visitation to begin with 2 years ago.
Okay.
Without the best interest
So
of
what
the
did you
child
think that
being
when they
found.
told me to keep the temporary orders in keep those orders in place, what did you think that meant? Like they meant for me just to keep it in place for 15 more days?
Until yes,
Okay.
until there was a hearing.
So can I tell you something about this area of the law that was new to me 2 years ago? What is that they never consider best interest of the child to switch everything all at once. That's never a thing. And so that's one of the reasons why they were saying these orders stay in place. Now you're saying all of a sudden this kid doesn't ever see Christian again. And
Can I bring the child in to speak for themselves?
no.
They don't want to be there.
And I'd like to remind too, the court is to consider a GAL. The GAL conversation happened during the trial and before Dr. Poppleton was enlisted after motion.
I understand
to do
all
a
of this
complete-
is
so I
really
just wanna make
frustrating.
sure,
I know, she
yeah.
doesn't understand. The funny thing is that
Dr.
I'm the one that raised the
Poppleton's already
GAL.
been
That's the thing, I'm getting burnt by something I raised
But
myself.
the bilateral custody order has already been vacated.
All right, we're not
You're
done,
not
we're done
understanding.
today.
Okay.
I'm sorry, we're not doing anything else today. Not because I'm upset or anything, but because we're out of time, because you guys are supposed to be at 8:30, which you didn't know. It was not your fault at all. That was not your fault.
I was going through my emails. I was like, did I miss something? And
So
I couldn't
Melissa,
find anything.
you didn't miss anything. There was some wires crossed. Originally, this was cited on by your attorney, I believe, for 8:30 a.m. and then
Special
something
credit,
else
yeah.
was written down for 9. So, but I'm out of time. I'm supposed to be in another hearings right now. But I will indicate to you that I'm confident that Court of Appeals didn't mean that we keep status quo for 15 days and then disappear. Even if what you're saying is right, is that the child does not want this, and maybe that's something that will, actually, the child's old enough now that there might be some information that we learned this time around that comes out in that. Stop talking, please. And, but I'm confident that that's not what the Court of Appeals would do, because that's not how our statutes work. In any case, let's say there's a guardianship in place because they're with one parent, and this parent's great, this parent's done everything they need to do, and they should be able to parent again. They're gonna make them ease into it because it's not healthy to just flip the switch like that. You may not agree, but that's the way all of our statutes are written. So, sorry. What's been indicated by me early on was that I wanted to expedite this matter. This is all slowing down in a way that I was hoping not to happen because I wanted you to get some quick resolution on this issue. Let me also tell you this. If a different decision was made by me or a different judge in a month or 2 months, they're still not going to flip the switch. So you need to be prepared for that. They are going to ease it back into Christian not seeing the child if that's the place it goes. Because nobody does that. And you should understand that. But I mean, if you don't, I hope that you understand that would be my responsibility or any other judge's responsibility in this situation. Unless there was something bad happening. So, I should not have even said that because I'm sure they'll hear about that later.
Your Honor, oh,
Go ahead.
Christian does not abuse or hurt the child, to be clear. That's not my concern.
Okay, so I guess new dates, and are we setting a trial date today, or do you wanna,
Okay.
and I just wanna make sure the temporary parenting plan is in
Yes, temporary
effect?
parenting plan's
Okay.
in place. If you guys could get together with Miss Gibson Smith to get your dates for trial, someone needs to file a notice to set for trial, which would probably be you, because right now they're getting everything they want with the temporary orders in place.
We had already set dates
Right.
because that's what you said at the last
Okay,
hearing.
thanks.
So then Ms. Rush said that she wanted 2 days, and then she said she wasn't available because she was too busy. But now she's out of the case, so we have the January 22nd, 23rd, the March 11th, 12th, the April 8th and 9th, or the 15th and the 16th were the ones that I emailed them before, and then they said we would just do it at the hearing and see how it
Right.
goes.
And I've got my list, thank you, Ms. Gibson Smith.
Which dates?
I have my list, I know January 22nd, I was just in Judge Cornell's arguing against the
that's right.
continuance, so that was the continuance request is denied, so I do have that trial, and my client's been waiting for that since March of
Okay.
2023.
Yeah, so what's
Your
the
Honor.
date?
January 22nd
What's
is
the next
that
one?
trial. Oh, the next one is March 11th and 12th. I do have a trial scheduled for March 11th, but I would try and boot that if
Okay.
we need it, so I can get everybody some
Does
resolution.
that date work for you?
March 11th?
Can we do March 12th though, just in case that way
Yeah.
I could do my trial on
Yeah.
the 11th?
March 12th?
That's probably fine.
Do you think one day is enough, Ms. Hedrick? Because I think that we can,
So let me tell you something
I don't
else. We're choosing a March date right now, but you want me to appoint a guardian ad litem, right?
I do.
Okay, so, that guardian ad litem is not gonna be ready by March, but I'll go out and appoint one and we'll have to move the trial if we need to.
Thank you.
Yeah, but you know, you guys are gonna decide on that and,
well, Christian has paid for the entire
I
Dr.
know.
Poppleton, so we would object to making any payments for the GAL.
Mhm.
We've already gotten a custody evaluation that I am going to want to, and that was one of the
Yeah.
things I wanted to talk to the court about. I haven't even seen it yet, so it may say something terrible for me.
Yeah.
It may say something, I don't know. But we just went through this entire process.
okay,
and
listen to this. But Dr. Poppleton didn't talk to the child?
I don't know. I wouldn't know.
Only for about 15 minutes.
Okay, did you want Dr. Poppleton to talk to the child again, or do you want a GAL? Dr. Poppleton's report's gonna be way better than the GAL.
Yes.
My issue with this is
I just
that,
need you to just make a decision, because right now I'm 15 minutes late to my next hearing.
I'd like the guardian ad litem, please.
Okay,
Yes.
you're gonna be paying for that, you understand?
How much is that?
It's a lot. Dr. Poppleton is way more, because it's more extensive, and I'm confused by
Can you give me like a ballpark?
Could be anywhere from 2,500 to 7,500, 10,000.
I have
just
not
don't
seen
know.
one less than
Yeah.
5,000.
Yeah. Is my client on Zoom? Okay, great. Thank you.
Okay, this is what we'll do. We'll have a hearing on February 9th to review things. We'll get that report from Dr. Poppleton, you'll have a chance to, what?
I don't want the report from Dr.
It doesn't matter,
Poppleton.
she's already paid for the report's coming.
It's not finished.
He was putting finishing touches on it when we started getting
He
these
hasn't
motions.
talked to any of the, he hasn't talked to any of the other people. He hasn't talked to Aubrey's therapist. He hasn't reached out to the school. He hasn't talked to anybody else that
Okay,
lives
we're
in
gonna
the
see you
house.
guys again on February 9th at 9 AM and we'll discuss these issues.
Do we have a March 12th trial date, Your Honor? But maybe
Yeah, you've got the
pending
March 12th trial
GAL.
date, which, yeah.
We'll see. Okay,
You
so
can
March
get back to
9th.
me on, the GAL.
Can I add something?
Yeah.
Please? I want you to understand that part of the reason, and this is all in the paperwork,
Great.
that I'm so down on my money right now, is because Christian stopped paying the mortgage for 5 months on the house and didn't tell me.
Mhm.
My house is going into foreclosure.
Okay.
And I have to move. I can't afford an attorney now. I'm trying to save up for first and last month, and now my credit's destroyed. I can't even get an apartment. And so I have a lot more going on that isn't here, but understand too, this is not in the best interest of the child, the lengths he is going to hurt me outside of the courtroom.
And we would object to that. Christian has done nothing but try to be above board in this case, so I'm just gonna blanket that objection right there.
I have all of the proof.
Okay.
That's what the trial is for.
Yeah, so, Melissa, what would you like me to do right now?
I do want the guardian ad litem appointed, and I will do my best to pay it.
They don't start anything until after they payment, so you'll come back, we'll see on February 9th if you have the money for a guardian ad litem, okay? And we'll talk, and then I want you to also make an argument why it shouldn't just be on your behalf.
My opinion was that
I'm not talking about it right now, I can't.
Okay, I'm sorry.
And then also, I also want you, I want to talk about this Dr. Poppleton thing. I think you're really shooting yourself in the foot. I do think you are. But I'm gonna let you do it. But what your other suggestion should be is Dr. Poppleton finish any investigation and you make a list of things that you want for follow-up for him to do instead of you not doing that. Because this guy is like one of our best, very neutral, very, like, counsel said, may end up saying, screw Christian. So it's like, I think that I can understand why you might be suspicious of our whole system because this hasn't worked out the way that you wanted to. Well, you have a month to sit there, a couple months to sit there and think about really what this should look like for you moving forward, litigation-wise. I want you to take time to think about this and not be stressed out here in this courtroom during this time because I need you to make the right choices for you and your child. And that has nothing to do with Christian. So if you want a GAL and you come up with the money by February, we'll get that going. or before then, you can cite this in and I'll get you a short cite and get you in here a special set. But otherwise, it's hard for me to charge both parties for this GAL when we've got a Dr. Poppleton, which I don't think was probably mentioned at the trial in the records, so that
Could we split the GAL? Mr. Poppleton has not been completed yet.
He's almost done, and we would object to
Yeah,
paying anything
I already told you
further.
guys I'm not addressing this issue right now. What I just specifically told you, Melissa, was I want you to think about what that argument looks like, so when we see each other next time, you can make that argument.
So the 9th is CR 60, Ms. Hedrick's pending motions.
Yeah.
The standing issue, will the court sign my proposed order so that we have
to get it started
We have
on
an
her
order.
behalf. On her behalf, we have to sign the proposed order, yes.
So, does the court have a copy of that? And
No, I may, and I'll sign it off, Doc, and I'll read
Okay,
through it.
all right, thank you.
You understand, wait, our old case doesn't stop until we do this thing, right? We gotta stop it. So this is all, this delay hurts you. Okay,
All right, thank you, Your Honor.
go ahead, what's
I
your
don't
question?
understand what I'm saying. What
You're not signing anything right now.
February 9th.
I'll see you back here February 9th or sooner. If for some reason you need to get this in front of me, you'll include her in the email, ask for a short cite with my judicial assistant. So, like, for some reason you come up with the initial funds. Even if you come up with those initial funds, I can reserve on whether the shared costs, which I can tell you if there's been a cost already paid to Dr. Poppleton, I'm probably not gonna make him pay that. But you can consider that.
And I just have a question. Does the court have the ability to appoint an attorney?
No, but I'm actually gonna look into it because it was really odd to me the way the appellate court addressed some of these issues. They almost addressed them as if it was a termination of some sort. That kind of confused me.
Constitutional issue,
Yeah, constitutional
But there
issue.
is no provision that I'm aware of in the
There is
background
not one,
for
but they raised
appointment of an
it.
attorney.
They raised it, so
There should be.
possibly. I mean, normally in a case, well, there's lots of reasons why there shouldn't be. The statute, I feel like they just don't like the statute like me. Because I don't understand their ruling in the way that it was. I think they agree with me that the statute stinks, but the statute's a statute until it's repealed.
That's exactly right. That's why I felt like it was a Pyrrhic victory.
Yeah.
I mean, here we are again, and we're gonna do the same damn
Yeah,
thing.
exactly. Yeah, they're gonna, yeah.
Gonna cost a bunch more,
Yeah.
and here we are.
Yeah. So, got it?
Thank you, Your
Okay,
Honor.
have a good weekend, happy holidays.
I'm gonna run over to Cornell's. I have one more. Can you let them know?
Yes,
Just so they
I
don't
will
leave
let
me
them
alone.
Docket complete? All right, I'm only a half hour late.